Well, good evening. Happy Friday, Valentine's Day Eve, February 13th, 2026. It is the conclusion of the second week of February, and 2026 is off to a raucous start. I did see in the chat people guessing and essentially wagering when I was going to start this evening. I saw at least two wagers for 9:07, so I figured I would go ahead and hold off for like 30 more seconds just to make sure that wasn't going to win. Well, how you guys doing? Good to be back. Sorry I was gone last week. It was a bit crazy and hectic. And I'm dealing with some lighting issues right now, if you can't tell. We're going to mess with it a little bit here from time to time, see if we can't figure something out. But, oh yeah, it is Friday the 13th. Why did my brain not even make the conclusion that it's Friday the 13th? I went through the entire day today without comprehending logically in my brain that it was Friday the 13th. Huh. Well, that's a thing. I'm doing great. We're off to a wonderful start. Wonderful start. So how you guys doing? Let's go ahead and get caught up on the chat. See what people are up to. Glad to see you guys here. Let people kind of pile in for a little bit. We have 3 topics this evening. 3. 1, 2, 3. We're going to see if we can make it through all of them. I don't know if we can. We're going to see if we can make it through all of them. We've got one remarkably positive. Can the sentencing be positive? Can the sentencing make you feel good? I don't know. We've got at least a topic that is going to be a little bit sensitive, a topic that's going to be a little bit going back in history with Murdaugh, back to a trial that I covered quite a bit, and feeling a little bit of vindication for how I covered that trial and comments that I was making that I got roasted for on the internet, specifically about financial crime information coming in and me claiming it wasn't necessarily relevant and it was more unduly prejudicial than probative. Yeah, did I feel a little bit justified or vindicated? Just a bit. And then we've got the possibility of taking a stroll and listening in on a bankruptcy creditors meeting, which sounds absolutely awful and atrocious until you realize the creditors meeting is for Laura Owens. And the U.S. trustee pops in and just starts grilling Laura Owens about all kinds of stuff. So we got a lot to cover. It's going to be very, very interesting. But as we get into it, settle on in, hang out, grab a glass of wine, grab a beverage of any sort you'd like, beer, wine, cocktail, non-alcoholic beverage, grab some popcorn. We've got some stuff to go through. Don't worry, we're not going to go through too much of the really sad stuff in the sentencing. I'm going to try and summarize that to the extent we can, because there was a lot that was going on there. Now, I do feel like I need to get a little bit angry before I watch the sentencing. So I think I'm gonna do this. I'm gonna do let's see. We're gonna do this as kind of a buffer as we get into this. We remember how to hit the buttons. Let's get caught up on chat. No commercials. No commercials. However, we're not going to play commercials, but I think we might have to listen to Justice Toll at least once or twice. Banana, no. Rob said grab a beverage. Mrs. Banana has no grounds to argue. You're exempt. It's an exemption. It's loud. Let's see. Random unread commenter, motion to hold Rob in contempt of chat. Contempt of chat is I will be held in contempt of chat. Being late. Yeah, I'll take that L any day. Pops Princess, hey Rob and chat, happy Friday. Happy Friday to you, Pops Princess. Glad to see you. Remembered for 9 months. Lady Fang 9633. Happy 17th Gotcha Day to my cat Fang. Happy Gotcha Day. Hawk Banana note, today at work, I accomplished amazing things that no one else could have. I have had several drinks in celebration. I apologize in advance. Oh no. What does that mean? How bad is it going to be? Okay. I'm glad you did amazing things at work. Really glad. We're going to see how it goes. Volkless. Rob, did you see SBF is back in the news again? I did not. Sam Bankman-Fried, what is he doing? Sam Bankman-Fried in the news. Were FTX witnesses threatened? SBF's retrial bid gains support from former FTX data head Daniel Chapsky, who disputes insolvency claims. SBF claims that Biden targeted him, demands new FTX trial. Okay. SBF files a Rule 333 motion seeking a new trial in the FTX case. Filed a motion for a new trial claiming that Biden's Department of Justice threatened witnesses into staying silent or changed what they had told the court in filing on X today. Why is Sam Bankman-Fried on X? Why is Sam Bankman-Fried saying anything? Isn't he in jail?
I hope so.
Yeah, I thought he was in jail for a long time. Rule 33 motion seeking a new trial. His filing names 3 people he said DOJ kept from helping his defense: Daniel Chapsky, Ryan Salome, and Nishad Singh. No, they weren't going to help you, bro. I dispute the facts. He's also asking for Judge Kaplan to recuse himself. No, I love Judge Kaplan. Kaplan roasted him. No way. Okay, well, that's SBF getting in trouble. You're clicky clacky.
I know. Sorry about that.
Name. Send Nick an invite. I will see. We're gonna wait till we get to Owens, lower Owens stuff. I need to get through some of the sentencing stuff pretty quick. Kristen M96, did you warn us Judge A is retiring? Did I miss it? I didn't realize you guys needed a warning for that. Judge is retiring.
And you did mention it last time you were streaming.
Yeah, she's retiring. The incoming chief, Judge Shannon, Judge Stephen Shannon is going to be. He's taking the bench. He's actually chief right now, technically speaking. They do this transition period where they overlap. Oddly enough, I had the chief that predated Judge White doing a mediation for me the other day, and he was telling me all about all the judges get together annually for this big judges brunch, retired and sitting in Fairfax County, and it's just massive. It's like 300 judges that all show up, and in my head, I'm sitting here going, the stories that exist, I would love to be a fly on the wall. Also a little bit terrified at the same time. Maybe it's not 300. I think I exaggerated the number, but it's all the retired judges in the area. There's 15 on the bench at a time, so it's a lot. Awkward Aquarian, thank God it's Friday, and thanks for the stream, Rob. Thank you guys for being here. Very much appreciated. Catherine Lynn Frazier, were you able to watch Judge A sentencing live? I did. We had a watch party in my office, and there's a couple of moments in the sentencing where I immediately was in my head going, oh, she's going to deviate up. And I think I shouted it down the hallway too. Baby Steps 22. Glad you're back, Rob. I hope your year calms down some. Hi, chat. How's Fam and Leo? Fam is good. Leo is nutless.
So Leo's good, but not in Leo's opinion.
He's not good in his opinion. That was that was a very difficult day. I felt like the betrayer of all betrayers because Leo loves getting in the truck. He doesn't like being in the truck while we're driving places, but he likes getting in the truck. So he likes the act of jumping in. He looks really excited. Then he cries a little bit. Then we get to where we're going and he's very pumped to be there. And he likes going to the vet. He's one of the weird dogs that does. I don't know why. He just gets excited because all the smells and all the other dogs. So on this particular day, this one day in question, of course, me, the only adult male in the house am tasked with taking him to his appointment. And yeah, it was really, really, really rough for me. So take him there. He's really pumped. He gets excited, gets in the truck, and he's like, I can't wait to see where I'm going. I'm like, you are not going to be happy with where we're going. And he gets to the vet. And he's like, I can't believe I'm here. I love being here. And I'm like, you're not going to be happy you're here. And he jumps up on the scale and he's like, look at me, Dad. I'm 72 pounds. I was like, that's cool, bud. You're going to be about a half or a quarter pound short after you come back.
71.9 pounds.
Like, okay, we're gonna lose a little bit of that weight. And then I pick him up at the end of the day. And he comes teetering out, clearly still drunk from the meds. And he looks up at me and he was excited to see me, but there's this defeated look on him. And I have never felt worse. I felt so bad. Felt terrible. But he is recovered. He is doing good. Yeah, he's still chaos, but he was wearing cone of shame for a while. Cosmooks, too late. It was 8 minutes. That's early for you. Yeah, it was. It was. And I didn't even push the stream 30 minutes. I started at 9 and I left it at 9 and I got on the stream at 9:08. Volkus, SVS mom is filing for him now. Oh, God. I don't want to know that. Really?
I mean, okay. Somebody's got to, I guess.
The dash in between. I miss you, buddy. Yeah. Okay. Hello, my spiffy, legal, mumbo, jumbo, talkie brothers from other mothers. How I've missed thee. Love y'all most. Glad to see you, friend. Glad to see you. Glad to see you. MD 18767 SPS mom signed his pro se motion. Oh, no, he didn't. No, she did not. She didn't. Oh, she ain't. I also adjusted my monitors on the issue is the bright is not a friend right now. So, you mess with one thing and all of a sudden everything that you thought you were fine with turns out not to be great. I'm going to need the computer to start computing. United States versus Mega Free. Let's see. What you drinking?
I am drinking a Coca-Cola. It's not exciting.
Gwen River, 70 pounds. Try explaining that to your 220-pound Mastiff. There are very few things I want to explain to a 220-pound Mastiff. Other than here is your steak, I'm going to be over here not bothering you. I have some wine if you want to add your Coca-Cola to my wine.
I mean,
Actually,
I'm out of wine.
Someone was asking me a question. Why is that not coming up? Someone was asking me a question the other day because they didn't know what they were going to drink. And they were like, I don't feel like having a beer and I really don't feel like having wine. I was like, have you had red wine and Coke? And they were like, you're kidding. That's a thing. And I was like, oh, let me tell you how I got tricked into drinking this crap. And I was like, it tastes like a knockoff or a Temu sangria. And they were like, you're lying. No, it really does. And they drank it and they were like, it really does. I was like, I didn't lie to you. Okay. Let's see. Oh, yeah. Signed by his mom. That's all right. Sure. Why not? Pro se filing by mom. Is that, those historically speaking, they do very well. They're very successful. Pro se filings in general. Vez from Quebec says, now my Burmese mountain dog wants my popcorn. Yeah, what is it with dogs and popcorn all the time? So, anyways, I'm sure that you saw a little bit earlier today a sentencing that occurred, right?
I did not actually. I have not seen the result, so no spoilers.
Okay, no spoil. I won't give you spoilers. I won't at all. I won't at all. But I wanted to get sufficiently angry before we watched it. I don't know if that's wise or not, but I felt like I needed to. So this is what I'm going to do to get sufficiently angry before I watch it.
Okay.
And it's going to be playing a bit of a press conference. You know the press conference in question, the one I'm talking about.
I think this is the one where I was raging about like why the DA wasn't letting the person who did all the freaking work talk. And I was like, hey, dude, you are a useless, I was going to say useless sack of hair, but he doesn't even have much hair.
No.
Yeah.
No, he doesn't. So we're gonna go ahead and swoop, and we're gonna get to this because this one, this we need to be sufficiently angry. So swoop. All right. So this is the press conference after Brendon Banfield's conviction. He was convicted of. Yeah, it was rough.
Oh, and I've got people saying that I am not allowed to bleed tonight. Fair.
No bleeding. No bleeding. That is prohibited. For those who have not followed the trial or know anything what I'm talking about, so Brendon Banfield went to trial in Fairfax County. Brendon Banfield was accused of aggravated murder, and he was accused of doing this with his au pair girlfriend. They conspired to unalive or kill Brendon Banfield's wife, and the way they did this was they created a separate account on FetLife, among other places, and they basically catfished this poor individual, Joe Ryan, to participate in what he believed was a consensual act of sexual violence. I know that sounds weird to think, but it's FetLife. Okay. So he gets catfished to go to the house.
Rob, your chat is like way ahead of you on this one.
Oh, I know they are. I'm just if there's someone who's not caught up.
No, I mean the chat is way ahead of you on knowing what FetLife is. I think you are the least.
You know what? Every now and then, people forget that I practice divorce litigation and divorce law, and I will say FetLife in areas, and people are like, "What is that?" I was like, "Oh, you innocent soul. Thank you. Okay, wonderful. Thank you for making me feel better about my life." But roped this poor individual into coming over to the house, and then at the same time, he and his girlfriend au pair conspired and went back into the home with 7-year-old daughter in tow. I think the daughter was 6 at the time. In tow, he creeps upstairs, walks in on the wife, and this individual wife must have been terrified out of her mind, proceeds to shoot the individual in the head, Joe Ryan, in the head. He is not fatally shot. He was probably going to die with that gunshot, but he was not fatally shot at that moment. Then proceeds to walk over and stab his wife multiple times. Juliana Magalhaes comes up, then pulls the gun out of her pocket and then shoots him in the chest, ending his life. The wife ends up dying at the hospital because there's certain light knife wounds you cannot survive. They basically were trying to pin it on this dude. That didn't end up working out. He ended up taking the stand. It was not convincing. Everyone didn't believe him, and they got the conviction. The DA then walks out.
His testimony was the sort of testimony that if he said, like, I have $20, let's go for lunch, I would make sure my account was able to make a payment for me and him, because I'd probably get stuck with that.
Yeah. So it turns out, as the trial is going on, we learn about the au pair, and we're like, this au pair is about to testify. And then you learn about the deal the au pair got. And the au pair who participated in the murders got a deal with the DA's office, or Commonwealth Attorney's office in this Commonwealth of Virginia. The au pair gets a deal that says, hey, if you testify, we will recommend time served, being 2 years. And then you can just voluntarily deport to Brazil. And everyone's like, well, that sounds like a really ridiculous deal.
That sounds like an excessively sweetheart deal.
For someone who unalived somebody or conspired to do that. And people were very upset about this, me among them. And people are saying, which a Commonwealth attorney would ever sign off on this? And you're like, well, the head Commonwealth attorney.
I've got two kind of feelings on that. Because, yeah, I mean, on one hand, I feel like the judge should take that deal and throw it in the trash. But on the other hand, the judge should, that deal should never have been made. And yeah, because
yeah. But we're gonna listen to some of the press conference.
And one of the other things about the deal that makes me what do you call it? I kind of feel like it's a bit of a shit thing to do with the deal like that, because there's a very real risk that a deal like that gets nuked. And so you're offering this deal and it's like, hey, have this deal. It's like, we're going to sell you a candy bar and it might be full of cyanide. You get to find out after you eat it, right?
Mhm.
So, yeah.
So, press conference, and then we'll get to the sentencing.
Her in a way that is measurable. It will certainly never account for
Volume okay, or do I need to turn it up a little bit? Turn it up.
I can hear it, but I'm the wrong person to ask.
I'll turn it up.
the lives that she was responsible for taking, but I think that the amount of time that she'll serve will be determined by Judge Ascarati, and I'm sure it will be appropriate.
So she hasn't agreed to your recommendation?
Correct. The judge is free to sentence her as she chooses within the statutory limitations.
It's 10 years, even the max is still
Hint, hint.
right, for someone who's plotted and set up Christine and Joe Ryan. And there's a lot of violence in this murder.
That is absolutely true.
Yeah, thank you, Jenna. I also wanted to add to this.
Can we pause?
You guys have access to Jenna if you.
Yeah. I know what you're gonna say.
Because it's really clear, and I mentioned this when I covered this press conference. Like, she's like, this deal is stupid, and I hope that the judge gives her every second of the 10 years, and also F the guy who made this deal. And then this dude shows up looking like, an inflated condom, and he's like, whoa, let me just, I'm gonna let her finish, but I just need to cut her off right now because she was about to say all sorts of things. And this dude is the guy who signed the deal. She's not. She's the person who was like, I'm just gonna convict everybody, thanks. So but that's why he's stepping in to shut her up, because he knows exactly what she's saying and he wants to, yeah.
And I'm seeing the chat here. I know that for some people said ads got turned on. I didn't realize that had happened. It was an automatic turn on. I just turned them off, so they shouldn't pop up while we're streaming. So if you guys are joining us live, you shouldn't get any ads anymore. Yeah, this individual right here is Steve Descano. He is the elected Commonwealth attorney for Fairfax County. Not the most popular individual in the world. The prosecuting attorney who was originally on this case, Klingon, was arrested for drunken public. We walked through his body cam footage. Klingon was involved in this case back when this deal was cut. But I can tell you right now that given the publicity of this case and what was involved in it, there is no way that deal got made without Mr. Descano signing off on it. And of course, he's going to defend his deal.
You have more questions for her. But no, I think it's really, really important that, we don't characterize this as a quote unquote sweetheart deal. This is the work of being a prosecutor.
Because it's
Valentine's.
Valentine's
Day. I think it's very important that we don't accurately describe this as a sweetheart deal, because this could really hurt my chances of re-election. Because if people accurately describe this, then they will also accurately describe me as some sort of moron, and I don't want that.
Yeah.
Chuckles McFuck here is doing a lot of sweeping, and yeah.
She still is taking accountability for homicides. When you take a look at what the relative culpability is, I think that where we have landed is appropriate. And quite frankly, Juliana, by testifying, answered a lot of questions, not only for us, but for the jury. Let's not forget how important her testimony may have been to some of those jurors. So her still facing up to 10 years in prison is very, very significant and well worth the cost to make sure that Brendon Banfield was convicted for a crime where it is a mandatory life sentence. As the law is written right now, Brendon Banfield will not walk free for the rest of his natural life.
Steve, is there anything else that a lot of times evidence does not get in?
So I wanted to show that to get sufficiently angry, because I don't really care for this individual very much. And Elf Wiggins, you bring up the point, arrested for drunken public. He was not arrested for drunken public. I misstated. He was courteously picked up by officers who realized he was a prosecutor, and they gently put him in the front seat of their squad car and drove him to his home, where he was able to sleep it off. But there is a sufficient amount of animosity in this particular county between the Fairfax County Police Department and this particular Commonwealth Attorney's office, this particular Commonwealth Attorney in particular. And there's not a big, lot of kindness going on when it comes to, let's put it this way, how the Commonwealth's attorney, this particular individual, Mr. Descano, is perceived by the bench. Okay. All right. So now that that has been understood, we are going to go to today, which is the sentencing of Juliana Magalhaes. And all right.
That I
No, ma'am.
am going to read.
You go ahead and read your statement.
Oh, so I read it now?
Yes,
Is
ma'am.
that correct?
Yes, ma'am.
Okay. All right. Thank you, Honorable Judge Penny S. Ascaretti, for giving me the opportunity to talk about the impact of the murder of my son, Joseph Nathan Ryan. My baby boy was born 2 days before Christmas, making
I
that
like her glasses.
I know. And don't worry, guys. I'm not trying to bring on the waterworks. I promise you. We're just going to get, this is Joseph Ryan's mom, because what you don't get is that in the beginning of this, because she was only charged based on the amended charge for the killing of, well, for the manslaughter of Joseph Ryan, the parents of Christine Banfield could not make statements because they were not the victims. So the court cannot consider the impact on Christine Banfield's family and anything else, which, to be honest, is remarkably significant. And hopefully they will get to speak at Brendon Banfield's sentencing when that transpires, even though it's going to be an LWOP as it is. But Joseph Ryan wasn't really mentioned a lot during this trial. I kind of felt like the prosecutor's office didn't do a very good job of highlighting him as another victim in this entire scheme. So I was glad to see this impact statement, because it really did. This one was very, very, very difficult to hear. Not easy.
that our special holiday. His middle name was Nathan, which means gift. Since Joe's murder, I haven't been able to take down my little Christmas tree, which sits behind the urn with his ashes. I say good morning to him each day when I turn on the tree's lights. But of course, that's not Joe sitting there. He can't say, I love you back. When Joe was taken from me cruelly and callously, murdered by Juliana and Brendon on February 24th, 2023, I lost so very much, more than I can possibly name. I lost my confidant, someone who knew me deeply, listened without judgment, offered advice with my best interests at heart. I lost my biggest ally and my cheerleader. That empathetic voice saying, Mom, you got this. Mom, you should be kinder to yourself. I lost my rock and protector. The person who flew down repeatedly to take care of me when I had cancer. I lost the comfort of knowing that my son would be there to care for me when I'm an old woman. with illness or dementia, just as he cared for his grandmother and grandfather.
So that's as much as I'm going to subject you guys to, and I don't mean that in a negative way. When I say you cannot hate this deal enough, you cannot hate this deal enough. That was Joe Ryan. And she proceeded to continue reading for another several minutes. And it was not the easiest thing to hear. Heard from another witness, and then fast forward.
I think that DA should maybe have to, maybe have to explain his choices to her. So, information around the courthouse is that the families are not too pleased with this. No kidding. Yeah. So here's where we're going to pick it up with the end of those individual impact statements.
And support of sentencing, which I have reviewed. In addition, 3 letters that you have provided as well. I reviewed those as well.
Your Honor, I'm going to hand up a few certificates that Mr. President. They can just be made part of the record there.
Okay. Are
And
these
no
okay
further
to
evidence.
can be part of the file, or do you need copies? We can make copies of them if you'd like.
That'd be fine, Your Honor.
Okay,
Thank
we'll
you.
make copies. All right, let me just review them, please. All right, we'll go ahead and make copies of these certificates and make them part of the record as well. All right, any other evidence from the defense?
No further evidence. Your
All right, argument?
Judge, the Commonwealth in this case, as the court is aware, made a recommendation, and the Commonwealth stands by that recommendation.
All right, argument, Mr. Kim?
Thank you.
Oh,
Yes, you are right.
That is the prosecution absolutely spiking that deal. We made a recommendation. We stand by it. That's the submissions. Go.
Yeah. No comments about how impactful she was. No comments trying to justify what is quite honestly unjustifiable.
I mean, I give her credit that she doesn't stand up and say this deal is clearly bullshit, and like she's staying ethical in those lines, but she's also not gonna defend it, right? She's like, nah, this is some shit. We all know it.
We all know it's bullshit. We're all here. Yeah.
Your Honor, the 2 witnesses that you heard from today made it clear that hearing the truth was valuable to them, to the Ryan family, and it was the truth that Juliana spoke at trial. And ultimately, it was her testimony that led.
Okay. While you're watching this, I've been in front of Judge Escarati a couple times, several times. She is very difficult to read nuances, but she has a few tells.
She does have a couple of tells that started to come out in the Depp trial.
Pursed lips are one. And there's a couple of times in this. There was one time in this when I was watching and I watched her eye contact to the defense counsel. And I was pretty much like, I shouted down the hallway to the rest of the associates and the paralegals who were watching this, and I said, she's pissed. Yeah.
Resulted in the conviction of Brendon Banfield. Until her cooperation, the Commonwealth had only a theory. They had circumstantial evidence, but no direct evidence. When Juliana finally came forward, she offered that direct evidence of what crimes she'd been involved in and what crimes were committed by Brendon Banfield. Your Honor, our position is that justice requires that the court follow the joint recommendation of the parties. Justice requires it because It was an arm's length agreement made by an experienced prosecution team with the approval of the head of the office, with the knowledge of all the facts and
There's your confirmation, by the way. People that were wondering, well, it's not very clear that Toscano signed off on it. It could have just been Klingon. Nope. There it is, right there in the record with the approval.
And the thing is you've got this guy's doing his best, but he should be coming at this a little harder. You know, she gave up her right to a trial that likely would have cleared her, because at that point, the prosecution had very little evidence, and their best theory has her as a figure who's coming in to help. She's the one who provided critical information, giving up her own, and like, you got to sell this, man, because this is, you got to sell this hard. And
it keeps coming.
Circumstances of the case, not just the facts of the case, but issues that would be presented at trial, the presentation of evidence and witnesses, sentencing guidelines, and many other factors that the parties consider beyond what the court might realize. Justice requires it because Joseph Ryan and Christine Banfield and their families deserve
that face. That's one.
Yeah. Oh, shit. I saw her make that face before during the Depp trial.
Yeah.
And it was when the lawyers were like completely off base. She made that face when Elaine was like, Judge, because this has been such a shit show, I want extra time. And she was like,
no,
I'm going to listen to you patiently.
Yeah.
And as soon as your like mouth is done the moving thing, I am going to be very relieved, and I'm going to shoot you down with a no. Like, just.
I made the comment that like her temperament is phenomenal, and she's very difficult to read. There's certain things that are easy.
Very careful normally, but she's pissed.
This is not hard to read. This is easy. This one's like, and the lawyer knows it too, because he's dancing a very fine line.
Oh, and you can hear him. You can hear that he knows, because you can hear his voice. Like, yeah, this is the I'm getting smoked.
Justice. By accepting responsibility in this case and cooperating, we avoided 2 trials. We assured the finality of the decision in this case, and we gave the jury and the Commonwealth and the court confidence that Brendon Banfield would be convicted, as he ultimately was. Justice requires following the agreement because every individual that makes...
Following the recommendation.
And that was when I shouted down the hallway and yelled, she's deviating.
Yeah.
Following the
agreement. I mean,
if
she's listening carefully, but she's only like, she's at this point.
Did you catch
she's made her decision. So
did you catch what she said? What she corrected?
She said following the recommendation.
And not listen.
Following the Banfield would be convicted, as he ultimately was. Justice requires following the agreement because every individual that makes...
Following the recommendation.
Recommendation. Yes,
Thank
Your Honor.
you.
And
yeah. Right then, you're fucked. You're toast.
Yeah, I mean, at this point, this is where you start changing gears, and you start trying to minimize the damage. And you say things like, even if the court finds that the recommendation is not sufficient, then something in the range of 4 or 5 years might be, that's where you start making the backup pitch.
Mm-hmm.
Because this guy should be going on the backup pitch in a real hurry. Because,
even the tone that she said it wasn't.
Yeah, when he says agreement and she says recommendation, it's like, ooh, son, you're in danger.
The recommendation was time served with a voluntary deportation to Brazil. Time served being 2 years. Yeah.
I addressed that in my memo, of course. Every individual that makes a difficult decision to cooperate does so with the belief that the recommendation would be followed or at least considered by the court. The Commonwealth, the courts, and prosecutors in courts everywhere in the country rely on cooperating witnesses to do what Juliana has done in this case, which is to speak to the truth and offer direct evidence of crimes, included those cooperating witnesses that they themselves have committed serious offenses. When a prosecutor makes a promise, the court ought to give it serious weight. Your Honor, I'll say I'm disappointed but not surprised that the Commonwealth didn't advocate today for the recommendation. I have deep respect for Ms. Bristler and Ms. Sands. And
oh, dude, read the room. Read the room, dude.
Well, there is a part, like to his credit, let me say this, to his credit, there is a part of what he says that has a whole lot of merit. And what it is that when a criminal defendant and when defense counsel reaches an agreement with the Commonwealth's Attorney's Office, there is good faith being negotiated back and forth between these two parties. And there is a good faith understanding that the DA is going to stand up and uphold their end of the bargain, which is to push this recommendation. And
I
there's an
agree,
understanding.
but he needs to be real careful how he says it, and he was not careful. So,
but there's also an understanding that there's a certain amount of trust that has to exist between the Commonwealth's Attorney's Office and the judiciary, where the Commonwealth's Attorney's Office is giving the judiciary or the judges recommendations that comport with the crime alleged, where the Commonwealth's Attorney's Office isn't giving bullshit that's completely disconnected from reality, that puts a judge in a bad position of having to impose a sentence. Like Judge Ascarati she's confined by the charge, by the amended charge. The recommendation of 2 years is laughable on its face. But the trust that exists right now between the Commonwealth's office and the court, you can hear it. Like, the court does not trust this DA's office at all.
2 years is ridiculous, right? For these facts, ridiculous. It's Christmas, and it's the kind of deal that I would tell a client, like, be real cautious about this deal because the judge isn't going to go for it. Like, you know, you can say 2 years. If the max is 10, you're getting 10. If the, you know, or close to it. I don't know where Judge A landed, but it's clear she's not landing at 2. And it's clear she's not landing at 4. I'm watching this and I'm going, you're in the 6 to 10. And if I had to put money, I'm going 8 to 10. If I'm, you know, like.
Well, and what's funny is you can tell that it's not necessarily him, this defense attorney, that she's mad at.
No, she's mad at
whoever cut the deal.
She knows the defense attorney's doing his job, right? And she knows the defense attorney, like, he's got to do this. She just doesn't like the deal. And I mean, so the defense, I don't, like, again, I haven't watched this. I don't see her yelling at the defense attorney because I can't see her, like, finding that the defense attorney acted improperly. But, I mean, she's also not buying it. And, I mean, I think that's a...
Gwynnie Bly says it great. Lawyer, quote, I must be an advocate. I must be an advocate. I cannot tuck my tail and run away. It's Captain Hand saying, please, ma'am, can she have less? It's all you got. It's really all you got with this set of facts, with this deal that you're trying to ram down the judge. No way. No way.
Yeah, it's I've been in these shoes where you're just trying to, like, push something and the judge does not want it. You're like, okay, I'm gonna do my best, and the judge is gonna come back with what they come back with. I don't fault the defense lawyer. I mean, other than potentially, I hope he had the conversation with his client of like, 2 years is a tough thing, and hopefully the judge goes along with it, but you got to be aware that there's a possibility.
Juliana doesn't do herself any favors here. By her hands are shaking. She's looking straight ahead. It's very clear she's not like. I know that looking at the judge is risky, but staring straight ahead and looking terrified ain't the best look either. So,
I mean,
it's the safer of the two options, because she could look at the judge and make the wrong face, and then she's how much more?
Yeah, and even something like crying or something could be mistaken, or like because the judge could say, "I didn't hear you crying when you were testifying about what you did, but now you're here crying when it's when you're looking at at what the penalties will be. You're here crying when there's consequences. Well, that's not going to get you far. So, yeah.
Do music to my soul, Rob. Do you think the lead prosecutor on the case was not in court today because she didn't want to be the one to stand up and recommend the time served? I don't know.
100%.
I'm not going to read into that. That could be. I mean, I don't know. It could have been another.
I read into that. I don't think she won. I think she wanted out of there.
It could be. But keep this in mind too. If she is one of their trial counsel, if she's one of their trial dogs, they want her trying cases. They don't want her basically standing up and saying, "We stand on the recommendation." I'm putting that resource to better use. KRAB 1791. Do you think the Commonwealth's attorney's attorney ever thought there was a chance in hell Juliana would actually get time served? Do you know how much worse it would be if he? I mean, I don't know which one of the two options is better. If he actually thought she was going to get time served, that just is gross. If he didn't think that she was going to get time served, but then made the deal, that's gross for a different reason. Like the defense bar can no longer trust the deals that he's making. So there's not a good way of reading that. It's pretty gross. Yeah. Random unread commenter. Think Texas can spare a few horses and rope for this DA? You mean the Commonwealth's attorney, the elected Commonwealth's attorney? I saw your comment earlier. DA, this prosecutor seems solid. Yeah, the prosecutor was solid, but we're gonna keep going.
The prosecution team, I suspect that this is frankly because of public sentiment regarding the agreement that they made.
Recommendation.
I'm gonna continue to make that mistake. I just
is
want to
that
touch
twice?
on a few
She's
things.
like, you didn't go back, right?
I did not go back. That's twice.
That's twice she's corrected him on that. Yeah.
Immediately.
And I mean, I thought she'd probably go along with it, but I also thought the prosecution would do a little bit more to not. And yeah, she's not happy. She doesn't like this deal, and she's making the defense lawyer needs to realize that. So yeah.
That I've just reviewed.
Yes.
Your Honor, the importance of the cooperation. Ms. Sands did communicate to me that she interviewed the foreman of the jury, who said three things that Ms. Sands relayed to me, that they believed Juliana Magalhaes, that her testimony was integral. That was the word that Ms. Sands used. In other words, central to their decision to convict Brendon Banfield. And third, that they didn't believe Brendon Banfield. Your Honor, that is important for the court to consider because, again, up until her testimony, which was presented first in the Commonwealth series of witnesses, the Commonwealth had only a theory. The Commonwealth had circumstantial evidence, forensic evidence, electronic forensic evidence, digital forensic evidence, and others. But it was Juliana who ultimately told the story firsthand of what occurred.
And this is what he's got to
because
ride
that
on.
decision was integral.
He does
in
better
the
here.
Jury's decision.
Yeah.
I think it can
this
be
is
said, and of course the court presided over the entire trial. You can determine her credibility yourself, but the jury certainly found it integral to their decision. And for that reason, the Commonwealth's recommendation, the joint recommendation, should be given heavy consideration by the court in this case.
This is the argument he needs to
I briefly
like really
wanted to
ride
touch on the
'cause-
delay in cooperating.
Yeah.
It was evident to the defense that from Juliana's first date of arrest, that they wanted her cooperation desperately. Her cooperation didn't come quickly. And our position is that at that time, she was still under the grip of Brendon Banfield, and the plan that he had convinced her would work. She still believed that there wouldn't be sufficient evidence for a conviction, and she was relying on Brendon's plan to get her through her arrest and prosecution. As she languished in jail, discovery dripped in. We really didn't receive significant discovery until after the preliminary hearing in this case. And even leading up to the trial date, we still hadn't received much of the digital forensic evidence that was made central to Brendon Banfield's case. Your Honor, the tipping point was perhaps the arrest of Brendon Banfield. That broke his grip on Juliana. The communications between Brendon and Juliana ceased. There were no further assurances that things would be okay for her, that they would have a life together afterwards. She was left alone, truly alone. No communications from his mother or family or other people, and no ability for her to actually contact her own family. She was left alone upon Brendon's arrest, and that was a huge factor in her coming forward. Your Honor, when she did come forward, we moved rapidly. We had a lengthy debrief followed by a plea within a day or two of that debrief. The next several months resulted in continued debriefings. We were available at every request of the Commonwealth. She continued to be candid and open with her statements, and I haven't heard any issues with her reluctance to answer questions in those debrief sessions. Your Honor, if she hadn't testified, there's a good chance that Brendon wouldn't have been convicted. First,
the other thing I'd say is if she hadn't testified, there's a good chance she wouldn't have been convicted. She gave up her very good chance at a trial in order to cooperate. Like, I mean, it's not just that she's helping get Brendon Banfield. You gotta hammer on she gave something up for this deal.
She did.
And that's what you've got to hammer on, right? She gave up her protections for this deal. Not so much that she was helpful, because, I mean, okay, you threw somebody else under the bus. Who cares, right? But, yeah, that's...
Well, this is a good question. Harbinger of Imminent Death asked a question. So let's say if you're in the defendant's shoes or the defense's shoes, do you tell your client, let's ask for a worse deal because I don't think the judge will approve this? Realistically, it doesn't, I don't know. Or it's this deal will never fly, or it's no, this deal is good because even the max that you have with this amended charge is 10 years.
I mean, that's a perfectly reasonable position to come in with, is like if she bounces it. But I have had a situation where I told my client, hey, the prosecution's offer is this, and the judge will never go along with it. So I'm going to come back with a higher proposal. And we ended up adding time to the proposal, and the judge very, very nearly was like, the judge was going to bounce it. And we had to fight to keep the judge at that higher deal. He would have absolutely bounced the lower one. It was one of the best calls I've ever made in defending anybody. So sometimes there is a place to go, we need a worse deal because the judge won't approve it. I've had prosecutors suggest deals that were in my client's favor, but unlawful. And that's another place where you have to step in and be like, can't, you know,
Yeah,
I love the deal.
Like, let's say they're like, hey, we're going to amend the charge, or we're not going to amend the charge. We're going to recommend time served on the aggravated murder. And that's not a lawful sentence on the aggravated murder. The judge cannot do that. So you cannot accept that deal because you can't make the deal. So the worst case, you kind of look at your client and you say, realistically, you are never walking with time served. But 10 years is not the worst thing in the world with what you did.
And I mean, I didn't think that she would toss this until I saw her tossing it, right? Because it's clear she's tossing it. You know, when she goes in and is like,
Yeah.
You know,
I had
but
talked to a couple of other of our criminal defense
it's
attorneys,
rare that judges toss
and
a joint recommendation. It's rare.
well, I hadn't really factored in how much the bench has not necessarily been in the circuit court on seeing things the same way as Mr. Descano's office.
His office is not popular.
No, I mean, part of it started back when he just declined to send prosecutors upstairs when people would appeal from general district court. So you can appeal from general district court where you get a misdemeanor charge. You can appeal from that and you get a brand new trial in circuit court. Well, for smaller offenses, when people would get their conviction in GDC, they would appeal it. They would want the new trial in circuit court. And he just wasn't tasking prosecutors to prosecute those cases. So rather than formally null pros them, he would just let them go upstairs without a prosecutor signed and let it get kicked. Judges don't particularly care for that.
That's grease. If you think it should be kicked, go up there and say that. And I can tell you, one of the things that gets the most credit with judges from prosecutors, at least in my jurisdiction, is when they go up and say, yeah, we think this is garbage. And we're inviting it to be tossed. I've had prosecutors straight up go and say, yes, this is all, like, you know, we're consenting to the appeal because the, we got a conviction improperly. I had a prosecutor midway through trial invite dismissal, and the judge was like, why? And the prosecutor's like, well, because I am not certain we have the right person, Your Honor. And I do not believe that, I can proceed with a prosecution under those circumstances. And the judge is like, okay. But I mean, judges remember that and they give credit to that, right? So, yeah.
Secondly, Brendon chose to testify himself. I doubt he would have done that without her testimony. He chose to directly challenge her statement of offense of her account of what occurred, and he was caught in his own lies. Beginning with shortly after cross-examination, the question of whether he loved her or not, and him saying, well, I didn't really love her. There were certain things that were in the way. And finally ending with his testimony about an important meeting that he was going to. Upon reviewing that testimony, his boss came forward to testify the next day that there was no meeting. Brendon's lies ultimately resulted in his conviction, but he might not have testified if Juliana hadn't been testified.
I don't hate that argument.
Your Honor, I appreciate the comments.
It was good. I thought this was probably his strongest argument. That realistically, Judge, what you're looking at isn't necessarily that Juliana convicted Brendon. It's that
she
Brendon
forced him to
Brendon,
testify.
and him testifying is what sealed the deal for him.
Yeah.
If he would have exercised his Fifth Amendment right, said silent, not said anything, and the state is left putting together that case on the forensic data only, without her testifying in any capacity, it's a different case. So there's a part of this where you do have to recognize that this was a contribution that she made to the case, even if you don't believe a single word that she said up on that stand. If she, by saying that, forced him to take the stand and sink his own ship, there was value add to the case.
I like that argument. It's a good argument there. I mean, really, they've got to argue that, like, she gave up something. I would be arguing hard that she was looking at an acquittal, that it was a difficult road to convict her if she stayed silent. And so that ultimately, what she's giving up, every minute of freedom that she's giving up is, is that. And Thomas Jules saying, you need to hear the Karla Homolka's deal. Have you heard of that one?
Mm-mm.
Case in Canada. It's really horrific. This Karla Homolka and oh God, I'm blanking on his name now. They were the Ken and Barbie killers.
Ken and Barbie
killers. And Paul Bernardo was the other one. And they were drugging and essaying and murdering various people, including one of Homolka's sisters.
Oh.
So at the time the prosecution made the deal, they thought that she was like a secondary victim, that she was forced into things. And part of that was because what is it? Part of that was because like there were tapes, and the lawyer found the tapes, but then hid them from the police. And so they made this deal, and then at the end of it, the tapes came out, and they showed that she was like an active participant.
Ouch.
So,
wow. Well, let's listen to the guy, lawyer. Keep going. Keep making your
Case
case.
for Ryan's family, and I've read the letters that were filed by Christine's family, and there's no words I can offer to console them at this time. But it is critical that there was no trial in this case, that there is finality for the families, and that there was cooperation by Juliana that resulted in Brendon's conviction. Your Honor, the last thing I want to comment on is the agreement in this case, the recommendation.
Thank you.
I had hoped the language of the plea agreement says that the Commonwealth recommends. It doesn't say they have to get up and advocate or pound their fist and argue to what extent the cooperation was important. But the court can weigh that yourself. It was critical. Her cooperation and testimony was critical to the outcome of Brendon Banfield's case. This was an agreement for a recommendation that was made with full knowledge of what the facts were of the case and what public sentiment might be regarding the agreement for Juliana in this case. The agreement was made anyway.
Recommendation.
Thank
you.
The recommendation was made with the input of all the victims.
Dude, you can't keep making that mistake.
It's also, when I say you can't hate Descano's office enough, that's what I mean. Is the point that he's making is that everyone that was in the room were adults, and they knew full well what the facts were when they made the deal. Ugh. Feel gross? Everyone feel gross? Yep. Good.
I mean, it is gross. It's, yeah.
The police department and all the important people as required by law. And there was no pushback at that time, Your Honor. I have a position in my sentencing memo, whether this is an agreement or a recommendation under A1A or
It's
C.
a recommendation.
I'll maintain that argument, Your Honor. I ask that the court follow the joint recommendation of the parties and impose an active sentence of no more than time served in this case.
All right, thank you, Mr. Campbell. All right, Ms. Perez-Magalhaes, if you could stand up, please.
This is a judge who's
stand up,
about to
Mr.
feed that
Perez-Magalhaes?
defense lawyer his crayons.
Oh, wait.
Her crayons.
Is there anything you wish to say at this time before sentence is imposed?
Yeah, I would like to really.
We're
Oh, no.
We're gonna do
Oh,
it.
no. No.
We're gonna do it.
No. So, for the people in the chat, I am a defense lawyer and have been for a decade. And in Canada, you've got a right to speak to the court before sentence is passed. So the judge will ask, do you have anything you wish to say? I have like 2 clients in the history of time that I will let talk. And one of them is because I can't stop him, but he's also very, very good at when he gets up to speak. And that is because he has a head injury and is speaking very much from the heart. And when he says like how sorry he is because he's kind of fucked up and he really wishes he could follow the law, he just struggles real hard because, you know, he's kind of a little broken. Yeah, that guy I will let talk, and I couldn't stop him because, head injury. But like, most clients will make things worse. Most clients are not capable of giving a, because anything you say is going to be scrutinized really carefully. Not just what you say, but how you say it. Do you have the right emotion? Do you have, and every little detail will get picked apart by a judge who's usually looking for a reason to go higher on the sentence, not lower, right? And so this is juggling dynamite right now. And that's before she has said a single word.
Yeah. She doesn't do herself any favors.
They never do. They almost, I mean, one of the best things she could say at this point would just be to say, Your Honor, I am so terribly sorry. And I understand that no sentence this court passes even begins to touch the gravity of what I've done. And I accept the court's,
not after this. I mean, yeah, you're right. If she hadn't testified the way she did, because Judge Ascarati got to watch her entire testimony.
Yeah.
And see that affect that she put on the whole time.
I mean, her affect at times seemed like she was kind of cheerful about how, how she's going to walk at the end of this. So, I don't know. Let's see the damage.
Statement. I have caused your pain. They cannot be measured and forever change so many lives. I pray for forgiveness from the Benson family and from Joseph Ryan family and from Valerie. I will never forgive myself for the pain caused. I hope that my cooperation in this case somehow begin to help, repair the damage caused. There is nothing I could possibly do to make it up to you, to your loss. Sorry. There are so many regrets, but this is my biggest. That's it.
I mean, I'd hope it's your biggest.
That's a tragedy I have been carrying with me, and I will always do. It's something I have nightmares with. A tragedy I know I can never take back the devastation of what I have done. I know that my remorse cannot bring you peace. I hope you might someday understand that I truly do not believe that his plan would have actually happened. I have grown so much over the past 3 years. I look back at my younger self at 22 years old, falling head over heels for someone 15 years older. They only seen his good side and clinging to someone that showed me love. I lost myself in a relationship, leaving my morals and values behind, and putting even my loved ones through this. My time in jail has been a time of reflection for me to better myself in more ways than I realized I needed. I had to find myself again. That's when I truly found God, when I had lost the desire to live, when I wanted to die. The guilt and feelings that I didn't deserve to live and that I was a monster were overwhelming. In God, I found the forgiveness and mercy, and I am restored. Jail is not a place you can bear to let yourself drown in those feelings. I wanted to disconnect from my pain and the guilt and get into survival mode to stay mentally sane, because inevitably, with memories come pain. Yet, I know I will live with this for the rest of my life. God and I only know the shame and guilt and sorrow I carry for all I have caused. Sorry for Joe's family and Christine's family. Sorry for Valerie, the innocent little girl who has so much love that will grow without her mother and our father. This I have burden to carry, knowing I could have prevented it at all from happening. I understand that I am to blame, and I'm truly sorry for the pain it caused. I hope someday I can be forgiven, as I hope to be able to forgive myself. Thank you for the opportunity to speak.
All right. Thank you, ma'am.
Okay, so this is something that I wanted to comment on. There are instances where people demonstrate remorse at sentencing, but very rarely, because generally speaking, what they're experiencing at that point in time is remorse. It is, but it's remorse for themselves. It is remorse that they are now facing judgment, and they are now facing the consequences of their own conduct. And that is when they feel bad for themselves for what they put themselves in, the position they put themselves in.
And a lot of people find religion in custody because it starts giving them the language of like forgiveness and mercy and so forth, which sounds really good. And it does not sell well in front of a court.
No, it does not. Because the other part about it is, go back to how she testified. If you looked at how she testified, talking about shooting Joe Ryan in the chest, there is none of this. None. Nada. Blank face. Darkness. That is where when you are talking to your client about whether they want to give a statement, if you had seen them give the statement they did or give testimony they did, you ain't doing yourself any favors.
No. Oh, I mean, having seen her testimony, I would not have told her to make this statement.
No.
This is one of those times when you just tell the court, like, my client does not wish to make a statement. It's the way to be.
Or you're allowed to give the judge a letter and just say, here's my written statement.
Yeah. And you know what? The lawyer can go over the letter and be like, yeah, this section here, we're just gonna cut. Like, you know, this is not good.
You mean like Sarah Boone, where she cut her letter down and then released the full letter after she was sentenced? Yeah.
I had forgotten about that. That is hilarious.
Yeah.
Right. In this matter, the court does find that the manslaughter charge was the large benefit of your bargain for testifying, which was a huge bargain in a plea deal. You could have been facing life plus 3 years, and now the maximum I can sentence you to today is 10 years. That's clearly a trade for your cooperation with the Commonwealth and what the Commonwealth offered. And you accepted that along with the Commonwealth's recommendation for time served, which is not an agreement, and as you know, not binding on the court, as we discussed at length at your plea. The reduction of the charge is a mitigation. I have watched your interviews and I watched you testify, and I just cannot find any further mitigation factors for your case.
That's an ouch.
Uh-huh.
You never want the judge saying, and I can't find any further mitigation.
Yep.
Like,
not that you bettered yourself, not that you did anything else, not that, I mean, keep in mind, this is a 24-year-old. She was 22 when she committed the crime. 24 years old. She is young.
Yeah.
Not good. No further mitigation.
You may not have come up with a plan, agreed, and an older man may have groomed you to a point, but I want to list for the record the facts that I cannot equate with accepting a time-served recommendation. These are aggravating factors either not fully captured or not reflected in the sentencing guidelines. Number one, until today, you have shown no empathy for the victim in this case. Number two, you were more involved.
Number one, until you got up and stood in front of me, you showed no empathy for the victim.
With the plan than you testified to. First off, there were numerous postings on social media platforms and text platforms looking for a target, texting and speaking directly with Joseph Ryan, encouraging him to bring the knife, and ultimately through the phone conversation, getting his consent, knowing all along you were bringing him to his death. lying to Christine and setting up the plan for the zoo, using her devices and hiding her phone, using a child as a pawn in your plan, waiting outside for Joseph to show up, calling Mr. Banfield to bring him to the scene, and at any point for at least the month prior or that day, you could have stopped this. The plan did not work without your full involvement. Number 3, having the loaded firearm in your pocket. Number 4, bringing a child.
The face.
Stop this. The plan did not work without your full involvement. Number 3, having the loaded firearm in your pocket. Number 4, bringing a child into the basement knowing 2 people were about to be murdered, to include the child's mother. Number 5.
It's the one place where her voice cracks, by the way.
Yeah. Oh, the judge is like, she's got a monumental poker face. Because a lot of judges would have fallen into either like a rageful delivery or a teary delivery.
This is the one part where Judge Ascarati's voice cracks.
And at any point for at least the month prior or that day, you could have stopped this. The plan did not work without your full involvement. Number 3, having the loaded firearm in your pocket. Number 4, bringing a child into the basement knowing 2 people were about to be murdered, to include the child's mother. Number 5, hearing Christine ask you to call 911, which you did and then immediately hung up. Number 6, seeing Joseph Bryan, who was shot in the head at that time, still moving and walking up to him as he lay moaning on the floor and shooting him point blank in the heart. Number 7, watching as Mr. Banfield stabbed Christine over and over again. Number 8, waiting 15 minutes before recalling 911. Number 9, telling a fabricated story for over 1.5 years, a story that depicted Joseph Bryan wrongly as a rapist and a murderer, an innocent man. And number 10, telling the child it was okay to call you mommy hours after the murder. Your actions were deliberate, self-serving, and demonstrated a profound disregard for human life. So let's get it straight. You do not deserve anything other than incarceration and a life of reflection on what you have done to the victim and this family. May it weigh heavily on your soul. So today I'm sentencing you on a manslaughter charge because that's what's before me. And the facts of this case demonstrate an intentional and calculated level of violence that is the most serious manslaughter scenario that this court has ever seen. Therefore, I do sentence.
As in, it shouldn't have fucking been a manslaughter charge.
Yeah.
Like if this is manslaughter, this is manslaughter. Is there manslaughter plus? Like, is there manslaughter like infinity?
You to 10 years in the penitentiary, as required by Virginia Code 19.2, 295.2. After you've completed your 10-year sentence, I will order an additional 2 years suspended, and you will be placed on probation pursuant to Virginia Code 19.2, 303. Since you have been convicted of a felony in Virginia, a sample of your DNA will also be drawn for the state police database. Are there any questions, Mr. Campbell? All right, anything further in this case? No, ma'am. Okay. All right. You're mandated to the custody of the sheriff. I believe that completes the docket. Is that correct? I believe so. Okay. Court will be in recess. All right.
That made me feel a little bit better today.
I didn't think she'd go for the full decade. I thought she'd go, well, the most I can sentence you to is 10 years, but we're going to knock a year or 2 off for the plea. Good for her.
The comments, I mean, the comments and the listed comments are probably the most succinct and well articulated grounds for giving. I mean, if there was a statutory scheme that would have allowed her to exceed 10 years, she could have.
And the thing is, that list was pre-written. Like, she wrote that list before she walked in to listen to anybody. But the purpose of that list is go ahead and appeal the sentence.
No chance.
You are not.
No chance. Like,
it's just, I am giving enough reasons, and I am absolutely, yeah.
The facts of this case demonstrate an intentional and calculated level of violence that is the most serious manslaughter scenario that this court has ever seen.
Because you can't normally get to manslaughter on those facts. Like, you just, like, you can't.
Yeah. Every aspect of that, every one of those little bullet points that she was saying out loud made me feel a little bit better. Each one of them, every single time. I was like, thank God someone is there. Thank God for Judge Ascarati, man. Who just stands as the backstop that makes us all feel a little bit more sane about what just happened. Oh.
No good for her.
Yeah. And you know what? She'll of course they're going to appeal the sentence. Are the Ohio Palm are the points beyond Joseph Ryan rationale for an appeal? No. You're allowed to consider all of those factors. You're not allowed to take victim impact statements from people that were not victims of a crime. But you're allowed to consider the gravity of the offense, the plotting that went into it, the consequence of the offense, both as to the victim of the offense itself and downstream consequences. The comments she made about encouraging Valerie, a 5-year-old, to call her mommy within hours of the murder. Also, congrats on Judge A not cracking like beyond that. She kept that together throughout the entire delivery, and I was like, this is phenomenal. Yeah. Judge Ascarati has a CVS receipt and a steel chair. That was probably one of the best deliveries. Made me feel better. Made me feel a little bit better about watching that horrible press conference that we watched and watching this deal transpire. So, and I don't mean lovely in that way, but what a just justified end to that saga.
And I hope the mom watching that, I hope she felt you know, sort of cared for, I guess, by the system, because
or at least the mom walks away and says, well, at least the judge did everything she could.
Yeah.
Like the Commonwealth's attorney's office might have let me down, but at least this judge did everything that she could. The system didn't, as a whole, didn't let me down.
But the judge was looking out for me.
Yeah. Yeah. So, Sandy is reminding everyone, please don't forget to do the YouTube things. Yes, guys, please hit the like button. Please consider subscribing. I know I've been MIA for a while. It's nice to be back and trying to get back in the swing of things more long term. It's not the easiest thing in the world. It was quite wild. Can Judge Ascarati retire in Virginia and then head to Massachusetts and get the Commonwealth judges straightened out? Yeah. She did an interview. You want to see what Judge Ascarati looked like when she was in General District Court?
Ooh.
Back before, well, she still had the ponytail when she took
in the
bench.
before times.
So now I'm not gonna play it because I don't want to get copyright hit because I know they negotiated. Well, not to say they negotiated, but I don't want WUSA 9 is the one who got the interview. So let's see. There's the courtroom. So yeah, guys, go check out WUSA 9 has the interview of Judge Ascarati, who talks about her time on the bench, talks about one of the things she's most proud of. And I think I've made this comment to you before. There she is.
Wow.
Look at that young judge. That is the Penny Ascarati. That's the Judge Ascarati that I remember. Yeah. With the ponytail back. Yeah. But she piloted, she was the driving force to the creation of the drug court or the rehabilitation court, the veterans treatment docket. So the veterans docket, she was a big deal for them. So pretty cool.
That is, I mean, she's had a pretty epic career.
18 years on the bench. Not bad. Baby steps. I'm happy for Judge A for her retirement, but it's a loss to Fairfax County.
Oh, 100%.
It is. It is. You have to hope that the lawyers that tried cases in front of her, the lawyers that tried cases in front of all the judges. I mean, Fairfax County's had, you guys have gotten to see Judge Ascarati, but there's a panoply of judges in Fairfax County that are great judges, like people you'd love to try cases in front of. You had the blessing of being able to watch one of the good ones for one of the most high profile trials that ever existed.
I mean, the thing is I say I'd love to appear in front of Judge A. I don't know that that's true.
One of my partners is like, I never get a good result. And I was like, you're too showboaty.
She does not like showboating.
No, it's like, you're too showboaty. She doesn't. No. Virtual juror. I love that Joe's family included Christine in their impact statements. Ascarati also did an interview this week. Yep, I saw the interview.
Yeah.
I watched that. Please go check it out. It's on WUSA 9. I might put the link to that interview in the description of the video. She's a great judge to be in front of. I had absolute pleasure to sit in front of her, or to preside, or not preside, for her to preside over a couple of my cases. Learn a great deal. Hopefully she passes it on. Gwynnie Bly, correction by the court, count number 3. So 3 corrections by the court, 2 self-corrections on the agreement versus the recommendation. Mostly harmless fuzzball says, to quote EDB from the Sarah Boone sentencing, girl find God before committing murder.
I mean, that's hard because I think one of the things that, God is big on is don't murder. I'm not religious, but I seem to recall that was like one of the things.
Yeah. Chloe diagnosed snarky. Joe Ryan apparently loved ugly dogs in particular. I think his aunt said his dog when he died was named Kitty. Cute. Yeah, the dog got a mention from the aunt in the victim impact statement, which pulled on heartstrings, but it was one of the endearing human moments during that. New Zealand butterfly girl Rob, when Judge Ascarati has retired, would you contact her to appear on FNF? We'd love to hear why she got into law, etc. I will make the request. Let me tell you this, though. Judge Ascarati, I don't know. I would have to approach that one pretty gently. Yeah, I'd have to approach pretty gently. Plus, I imagine that she's probably going to go to mediation and be a mediator. And one of the things is I kind of want her as a mediator. And if people find out that I was interviewing her on my YouTube channel, I might have people just trying to disqualify her as a mediator.
I, on the other hand, would love to interview her if she would put up with it.
I will ask questions if she will be willing to do interviews. I know that I actually want the opportunity to have a chat with her after she is no longer on the bench.
I would love to
the
just talk
YouTube
with her and just be like, so the whole Deptford Herd thing, how much was that a chaos? Like, how much was that chaos? How much did you hate those of us who were sitting in court watching? Those kinds of things. Because
a little bit in that interview, but that interview is short. It's like a 10-minute interview. Like I want to sit down with Judge Ascarati and be like, hey, so can I just pick your brain for solid 3 hours? Like, just
Rob.
Yeah.
I feel like there's something that just happened that we need to talk about.
What?
I'm dropping a link. This dropped like an hour ago. It stars Benjamin Armstrong.
Is that Ben Armstrong, Bitboy Crypto?
Bitboy Crypto.
Read this real quick.
Bitboy Crypto having a real bad day. Scroll to the bottom.
$2.828.
Couldn't have happened to a nicer guy.
What the?
Check the breakdown.
I did.
Okay, the chat needs this because the chat is seeing us react and they don't know what we're reacting to.
Hang on,
so
let me do a swoop real quick. Proceed.
So Bitboy Crypto just had a judgment issued against him for $2.828 million, which is not a small amount of money. And they break it down. $750,000 in mental anguish damages, $78,000 in reputational damages, and this is the solid, like, amazing one. $2 million in punitives. Which, like, the court issuing $2 million in punitives, which is, you know, more than double the rest of the debt. Like, they just curb stomped his ass. Yeah. But when you see what he was up to, like, whew. I may have to cover this judgment just in and of itself, but
this has to be this is a because I can't go through the whole background of this case. Not now. Like that's a whole backstory.
It's a whole backstory, but yeah. Bitboy Crypto was
it. You know,
Bitboy Crypto was publicly calling Mr. O'Leary a murderer and claiming that he paid millions to cover up his role in a murder.
Wow. Okay. That is something.
And if you're wondering, Kevin O'Leary, like Shark Tank Kevin O'Leary? Yeah, Shark Tank Kevin O'Leary. That's the guy.
That Kevin O'Leary. So Bitboy Crypto, so that people are wondering who we're talking about. Let me see if I can't find a photo of this individual. Not that I really want to see his mug, but oh, he does not look good these days.
No, he's having a bad time now.
Like not at all. Like not like not in the best. That's Bitboy Crypto. So
in better days, yeah.
In better days, like he had a big YouTube channel. He was kicked off of his own YouTube channel. Got into a ton of personal troubles. He was having an affair, and he was driving to the house of his wife with the girlfriend in the car or something like that, trying to take cars back. Really, like his downfall was something of just epic proportions.
Yeah.
Like collapse like you could not imagine.
And to the extent he's got any money, like Kevin O'Leary is going to come after him for every dollar of that.
$2.828 million. Wow. That is, and this is a 19-page opinion.
Yeah. Couldn't happen to a more deserving fellow.
Oh. So, stay tuned to Ian's channel. That's going to be interesting.
I mean, it's mostly going to be a it's mostly going to be a dunk. But yeah.
This is remarkably generous. The Winslow Wonder 7097. Thank you. That's a very generous super chat. Hey Rob, glad to have you back and a pretty good time. And I had a pretty good time for me. It's been damn near 4 months since my passed away. And I'm honestly a wreck today. He was also into woodworking and made me some awesome things just trying to get homes for his tools. I'll tell you what, Facebook Marketplace and Facebook in general has groups of woodworkers that are there. I would also strongly encourage you to find a local wood shop where they teach and
Yeah.
see if they might be interested. If you were to donate or if you were to give them away, put those tools in the hands of younger kids who are learning how to do this. I'm very sorry for your loss. I hope that we can bring a little bit of comfort, and hopefully that you can look around the house to the things that imagine your husband or your father. I don't know if it was your husband or father, but whomever you lost made, and see the things around you, and keep in mind that they're always going to be with you. But donating or giving those tools is a phenomenal way to make sure that that legacy lives on. So I'm very sorry for your loss, and hopefully you're comforted by, like I said, the things that are surround you that he made and make you feel a little bit more at home. So, tool library is also good too. Yeah, it is. I like the idea of trying to find a local school or a local wood shop that teaches youth. I know that various programs will try to get troubled youth into hobbies like that, whether it be automobile mechanic, woodworking, contracting. Just give them something to do with their hands because it keeps them. Yeah, that's a good one too. Catlin, check local adult resource centers who teach adults with disabilities how to do woodworking. A shop like that would love these tools. Yep, there are tons and tons of places out there that put these things to really good use. So I very much encourage that as an outlet. But don't give them all away. Keep a couple of them just for you. Okay. So we get caught up on some of these other super chats, and then we will roll on to the next topic, which we're going to be brief. We're going to go through the Murdaugh, and I know you had covered it before, the Murdaugh appeal. I thought the appellate argument was fascinating. Usually appellate argument can be boring. The appellate argument in the Murdaugh case hit a lot of topics, and it made me go back to how we were covering that trial. Remember when you and I were talking about the trial when it was going on, and we're like, this is a lot of financial information that's coming in that is insanely prejudicial, and bad guy bad, therefore bad guy do murder isn't going to hold up. And then there's Courthouse Becky.
Courthouse Becky is kind of the showstopper on this one.
I was surprised they got into as much of the evidence as they did. It looks like they might come back on both grounds. So I think he's getting a new trial. I think the question is whether it's a new trial or a new trial with instructions. So getting caught up. So Runkle, no bloodletting night. None indeed. Thank you, Mirage. Phoenix Fire. Hello, Robin Runkle.
Almost
hello,
healed.
Phoenix Fire. The world wonders. I'm sorry I missed this when he was on. The DA looks like Murdaugh, the Murdaugh head guy with the bald head.
I
Catlin,
stand by my description of him.
Timu, Agent 47.
Nope, that was not the one I was thinking of.
Which one were you thinking of?
He looks like somebody inflated a condom.
Oh, yeah. Well, that was one. Let's see. Catlin got to order a new Special Olympic uniform today. Been begging for 2 years and finally got the funds together. Very happy, Coach. Congratulations. Hope the uniforms look spiffy. Time Lords, thank you for gifting memberships. Good to see you, Time. It's been a little while. MDL 8767 on the plus side. The answer is still a cop. Is no. You mean it's to the prosecutor? Yeah, no longer still a prosecutor. Klingon is no longer still a prosecutor. Although I did hear that he was shopping his name around to anyone who would take an interview. And
yeah, I would not be.
I encouraged a few friends to not take that call.
I mean, if he sends a resume, you can, like, at the very least, it works as toilet paper.
No, it's
It's a little
never
rough,
really
it's a
been
little
comfortable.
coarse,
It's
but
rough. Doesn't really work that well.
just send it back and ask him if he's got one in 2-ply.
He might. You never know. Really a Cat Mom, thanks for gifting memberships. Mary Matilda May, thanks for becoming a member. Really a Cat Mom, thank you for gifting additional memberships. Very kind of you. Mary Matilda May gifting memberships. Very, very kind. Growing the community. Tracy Sires, thank you for gifting memberships. Again, growing the community, and Tracy Sires coming in. I shared this elsewhere, but it makes me ill that even with the max sentence, Juliana would be younger than Joe and Christine were when she is released. That part. Like I said, you cannot hate this plea deal enough.
Oh, I mean, I think I can, but
really, because I'm still trying to find the limits.
I am pretty thorough in my ability to hate things when it comes to it.
That's true. That's true. Winnie Bly, I was hoping to see your response. Well, you got it. Like I said, I was a happy camper listening to Judge Ascarati rattle off that. I didn't necessarily shout "Go off, Queen," but it was in my head like at full volume as that was happening. Mel the Frog, well, bonsoir, everyone. Bonsoir indeed. Auntie Lime, is this still the lawyer Mama Banfield bought her? I think the same attorney. Winnie Bly, I sat with my 17-year-old cat as she crossed the Rainbow Bridge. The mom and aunt statements were brutal, but amazing. So glad we got to know Joe better. R.I.P. Yeah, that part, I felt like he got very much lost because Brendon was the one that was on trial. So that was one comment I had about the prosecution in this case where I did not particularly care for how they handled it. I felt like he was very much missed. Poison Elf, Rob, can you score an interview for the channel? Like I said, I will try. Even if I can't get it for the channel, I will see if she will allow me to at least have a chat with her and then maybe convey some of that chat to you all. Random
And
unread.
if you can't because of local restrictions,
I say, look, here's my friend. Look, here's what I'll do. I'll point him to the different interviews you've done, and I'll say, go watch Judge. Go watch those interviews. Watch Nick Lohan.
And you will recognize him from the Depp trial as guy not causing trouble.
Yes, and he was sitting next to me, who was also a guy not causing trouble that you've seen try cases. Like not that problem. We behave, I promise. Random unread commenter, I don't know why draw and quartering has become my default solution for piece of crap prosecutors from the last few trials, but it doesn't morally feel like the wrong one. And this is what he was talking about with the DA, the elected DA. Not a fan. Big Apple Hoosier, worst Banfield, Murdaugh, or the nut from Arizona? Banfield. There's a part of Banfield.
Testimony was pretty bad, but the guy whose story was the whole like Casadas, that's the guy. His testimony was real bad.
Yeah.
Like I've seen bad testimony, but Casadas really, yeah.
Sorry, I was Big Apple Hoosier. I got yours. And then virtual juror curious. Do you know if there's tension within the Commonwealth's office in general? Seems with this kind of deal, there might be some underlying. There is a whole lot of tension. There's a whole lot. The elected Commonwealth's attorney is very, very strong in his opinions that tack in a certain direction that make a lot of people in Fairfax County uncomfortable. It goes from the top all the way down. So I don't know how much I can get into. It's not a pretty scene. Hey, gentlemen, question for the both of you. Why couldn't the judge bounce this deal? Could she have tossed it before it was agreed to? No, because here's the aspect
she doesn't
of
get to see it until it's agreed to.
Well, it's not even that. It's the DA has the absolute prosecutorial discretion on what charges to bring. They are allowed to amend their charge down, and as long as the facts satisfy the actual elements of the new charge, the court can't go in and say, hey, I'm a judge. I'm going to go ahead and, because I think the facts are sufficient to up the charge, increase the charge. That is a purely political decision. We trust the elected prosecutor to exercise that judicial discretion, not judicial, prosecutorial discretion to determine what charges are appropriate, because we as society have elected that prosecutor into office to say, we want you charging these things really harshly. We want you not charging these things really harshly. Look at marijuana possession offenses. That's a really good example where you see prosecutors exercising discretion and not charging certain possession offenses. This is 100% in the realm of the prosecutor as to what charges they're allowed or what charge they want to bring or rely on. Mega's autistic. Glad to see you here. 29 months celebration. Dina Kawaji, thanks for gifting memberships. Catlin Shoot, FNF Fridays are the best Fridays, y'all. They are great. CS Tears, Lawyers and Dragons return. That is always the hope. Chris Cat Queen, we should do a meetup retirement party for Judge Ascarati. That would be very
I feel like she would be annoyed by that.
I feel like she wouldn't like that. Like, hey, Judge, here's a lot of people who you don't necessarily know, but who have watched you, who want to celebrate what you do and your job.
Yeah, I feel like she would have opinions, and those opinions would be F and off. And
one of the things that was one of the reasons why I want to talk to her is there's the notion that, and she makes a comment in her interview about the chaos and the circus of the media. And to some extent, I very much agree with her. But again, there's also places that are not necessarily trying to stir up drama or rely on the drama, but are actually trying to explain what the court is actually doing, why this is important, what aspects of this trial are. And there's people who take a very important fascination in how their government works. And I wish I could explain that to her, to say that, you know, Judge, we are in this world every single day. It's not approachable. It's scary as hell. People don't understand it. I want to make people feel more comfortable about seeing what this is and how it works and how it should work. And there's no better way of doing that than showing it to people. I'd love to have the opportunity.
And I suspect she'd say something like, Mr. Morton, I'm well aware of what you do.
I don't know if I want to hear it.
And you'd be like, oh shit.
Yeah. At that point in time, I'm just going to be like, well, Judge, with that comment, I will just hide. I'm just going to, yeah.
And she'd probably be like, that is a good choice.
Not when she retires, I'll be like, yeah, but you can't sanction me yet. And she'll probably be like, yeah, but I know every other judge that can. I'll be like, damn it, you're right.
She's like, not directly, but give me a phone call.
Remember that one case you had in front of Judge Shannon? Yes, I do. Music to my soul. Rob, can you please explain how Judge Ascarati was able to add a suspended sentence after 2 years with probation to the maximum sentence? Isn't that standard? For that charge, it is. She referenced the statute 19.2. Where is it? Post-release, so 19.2, 295.2, post-release incarceration of felon sentence for certain offenses. For offenses committed on or after July 1, 2006, at the time the court imposes a sentence upon a conviction for a first violation of blank, court shall impose an added term of post-trial incarceration of 6 months. It gives a structure where it's a mandatory. If you are convicted for a violation of certain charges, there's a mandatory post-trial suspension, which allows for them to continue monitoring. The reason why is they don't want to release you from the prison right back into the population. They want to at least be able to monitor you for a period of time while you reenter society, because for certain offenses, we view their threat to society as being so significant that we trust that what am I trying to say? We trust that they're not going to be recidivists. We trust that the corrections department is going to do their job and they're going to come back out a model citizen. It will surprise you none the least that that is not necessarily the case, and that individuals that are released after committing these violent crimes, generally speaking, if you're looking at the population of people who are recidivists, they are among the higher percentages. So that's why you want to be able to at least have some conditions that allow you to monitor them, which is why it's a suspended sentence. It's not time that she's actually serving in incarceration, but it's time that she can be required to report to court services, required to have certain conditions of her bond, that kind of stuff. Really, a Catman, thank you very much, man. Harbinger of imminent death. When it comes to oral argument, do you prefer a trial judge or an appellate bench? Also, Runkle, are you done with the Karen Reed sidebars?
I don't know. I could do more sidebars. Are people interested in more sidebars? I could do more sidebars.
I don't know. I haven't seen any of them. So, yeah, I don't know. Let's see. For me, I like trial judges just because let me put it this way. When you listen to certain appellate arguments, you will hear some of the appellate judges and you can tell which ones have ever tried cases. You can probably, right? The ones that have never tried cases, they say, well, we know very well that that in the trial court does this. And you're like, no, you don't. No.
Yeah.
That's not what,
because that is not actually how
happens.
that works.
So I like being in front of trial judges because the trial judge has walked in my shoes and there's a way that I can say things without necessarily needing to lay it out for them. Or they're not speaking from a place of theory. They're speaking from a place of practice. But then again, appellate judges, I like fascinating arguments of law. Those are fun too. And you don't get to do that in trial a lot. So it varies, but I prefer trial court. You, Ian?
I like both. I kind of like appeals because they're much more of an intellectual game, and I like intellectual games because at the end of the day, all of the evidence is already in, right? You don't have a bad evidentiary bounce at the appeals level. Whereas in trial, you can walk in and suddenly your client says something or a witness says something that is just completely unexpected and can absolutely annihilate your case, right?
That's fair.
You've had the moment your client's up on the stand and they say, you're like, oh, so why'd you have a FetLife account? And they're like, because I was cheating. And you're like, damn it. These kinds of things, right? Your client just says something. Yeah.
No, that's fair.
I had one where my entire argument was going to be based on this person not getting a good look at this person, because what they had said was that they were driving in their car and they saw, they saw this happening. And that was what they put in the police statement. What they said at trial was that they were driving in their car, they saw this, and they got out of the car and went and walked over to have a look. And so they got much closer. And so I was like, okay. And I was like, but you didn't put that in your statement. They're like, I thought it was clear in the statement that I got out because it's it's far away. That's just how I noticed them. Couldn't rattle them on cross, even though it was like, why didn't you put that in your statement? And I knew I was done. Because that witness identifying them like that, it was like,
you're tough. Yeah.
Oh, I was just like, yeah.
Part of it is the trial. There's more risk and it's less the intellectual argument. There's risk and I like that because I like playing the chess. I like trying to work my strategy into it with that risk. Something about it. I don't know. I like appellate argument too, but as far as my experience is trial. So I can speak very little about appellate advocacy other than my observations, but I haven't been in the trenches in that. Mama Betts, yay, FNF, been missing my Friday night fix. Glad to have you here, Mama Betts. Crazy Cat Queen, Judge A equals Marine, knows the hail farewell tradition. She is a former Marine. She talks about her service quite a bit, which is why the veterans docket was so important to her. And again, you would be remiss if you did not walk into her courtroom and show the utmost of respect for the station that you are entering into. Let's see. Hunk Banana, no, I want to open a franchise chain of bar and grills attached to adjacent to every courthouse in the country called Side Bars. Seeking investors, drunken whims only, please. Tell you what, those courthouse bars get a lot of foot traffic. Sometimes good, sometimes not. Good point, Nerdy Rider Cat. No such thing as a former Marine. Very good point. Very good point. Once a crayon eater, always a crayon eater.
I mean, they don't get any less delicious.
I've known too many Marines. Okay.
Most Marines will laugh at those jokes, and the other ones, you're for a bad day if you make those jokes around them. But most will laugh.
Yeah. Okay. So as we get into Murdaugh, I feel that instead of our typical swoop, I need to do this one.
Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
So you think that you're aware of the fact that some of these on the scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am, yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
All right.
That lengthy pause. All right.
Stare down. All right. Sure. We believe in courthouse, Becky.
Catlin J. Shoot saying 3/5 of the groomsmen in my wedding were Marines. I wanted to get the boxes of crayons as their groom's gifts.
Yes.
But hubby said no. You should have gotten them something else, but you should have also included the crayons. Like, get them like a picnic set with the crayons tucked in.
No, I've got a better idea. You know what you should have done? Should have taken lollipop sticks, like popsicle sticks, and melted the crayons into a shape of a lollipop. Oh, that was bad. That would have been really bad. Yeah. So, courthouse Becky Hill. I don't want to talk about Poot.
You don't want to talk about Dick Poot?
I don't want to talk about Dick Poot. Poot is, man, when he went through his monologue, for those of you guys playing a little bit of catch up, welcome. But also Alec Murdaugh. Poot? Yeah, Dick Poot. Alec Murdaugh was convicted for the brutal murder of his wife and son. And the jury came back within they had enough time to sit down and maybe they had enough time to line up for the bathroom, use the bathroom, take a poll, came back. He's guilty. Probably one of the fastest guilty verdicts I've ever seen. The entire trial was maybe 3-4 days, probably 5 days about the actual murder. And then 6 days was a discussion of financial crimes. Were the financial crimes charged? Nope, not in this one. But they were deemed relevant for motive purposes. They were not excluded. after the trial, turns out that the elected clerk of court, who courthouse Becky Hill, had she had a tell-all book behind the walls of justice.
I mean, she wasn't telling all. She was just telling the parts. Like, she left out the I was interfering with the court thing. That was left out.
Yeah. Turns out that she was having communication with the jurors that she should not have had, like at all. And that created a problem because some of the remarks that she was alleged to have made around the jurors was, don't trust the defense. This is the elected clerk of courts, who in the eyes of the jurors is the second most important person they see, judge being the first. So it's of significant consequence when the clerk is making comments. Now, there are allegations that Justice Toll found credible that she was making these remarks, rather that she had hoped and desired for a guilty verdict because a guilty verdict would sell more of her books. Which is the problem. Little one, you know? Oh yeah, she also plagiarized it too. I forgot about that part. Plagiarized some of it. So very, very classy individual. And after the trial that resulted in a prompt conviction of Mr. Murdaugh, all of a sudden the state gets hit with these different allegations, and the state must have been there and smacked themselves in the head and just gone, are you fucking kidding me? Like, there is no way. Really? Are you kidding me? We went through that trial and all of that effort, all of that time picking a jury out of how many people keeping it in Colleton County. And the clerk was behind the walls of justice saying these things.
Mm-hmm.
So after Creighton Waters, I don't know how he would have handled that. I don't know. How would you have handled that after that trial? I probably would have, I don't know what I would have done. Probably something destructive, very destructive.
I think I would have just been like, screw it. I'm quitting law. I'm going to go and be a badger. I'm going to go into the woods and, you know, that's my calling now is badger.
Yeah. I would have been very, very upset, to say the least, if that trial that I had done was all of a sudden because of the clerk. Like, of all the things to fuck up your trial, of every single thing, you expect a witness to go sideways. You expect disruption to the gallery, expect disruption from outside. I mean, you expect any number of different things that you're trying to dodge mistrial left, right, and center. And all of a sudden, after the conviction, find out the elected clerk of the courts is pulling this bullshit.
Oh, I mean, I would have been going, it's going to be my mission to see that she goes into jail.
Yeah. It was something else. I don't know that I've ever, this is a set of facts that I've never heard of in my entire career. You? Anything close to it?
Nothing. I mean, this is the kind of thing that if it had shown up in a book, I would have laughed at it as this is insane, right?
This is so ludicrous. It doesn't bear even commenting on, like, why would you publish a book this stupid?
Yeah. I would seriously have just been like, this is the least realistic thing I've ever read. Like, I would have been mad at that book, like straight up mad.
Yeah, I would have been not pleased at all. So where we are is we are now hearing the appeal itself. Yes, Becky pled guilty to perjury for that. Yep, I know. She did. She did indeed. So Dick Harpootlian, who loves to wax poetic and talk about history, which I mean, fair, he's lived most of it.
Rob,
what? He goes up there and talks about his first 5 minutes of talking about how 50 years ago on this day, yada yada, he was sitting right over there and he was listening to some.
I don't know that he's that old. I mean, look at him. He could just be a Muppet. He could have been stitched like last week.
He's something else. He is something else indeed. He's a character. This lovely individual, mind you, also held up a shotgun in open court, aimed at. Was it the shotgun or was it 300 blackout? Which one? I think it was shotgun.
It was the AR.
Shotgun. Was the AR?
Yeah,
that's
it was
right.
the AR.
Pivoted back, ends up pointing it in or near the direction of the prosecutors, and says out loud, "Tempting," like things that you just never do or say.
Oh, I mean, if I pulled something like that, the court would just be going, all right, this is going to cost you something. And the question is it going to be dollars or days? Because, you
I
know,
don't even know if I get the option.
I think the court might might give me the option of dollars with the threat of days, but it would be it'd be open. I mean, here they could actually charge you with that, you know.
Here's what I'll say about Dick Harpootlian's job. Dick Harpootlian's job in this particular instance, for his argument, for his part of his argument, he was getting softball after softball after softball. The justices were basically just saying, would you like the easy answer or the easier answer? Oh, you're struggling with the answer? Let me go ahead and give you the answer I'd like you to give me. And you can just
there was a
repeat it
lot
back
of
to
that.
me.
There was a lot of, you're going to win this, so let me just tell you how to make the arguments that we want to hear. And yeah.
It was. And it wasn't until we got to Creighton Waters where things got very interesting. So I don't know that I really want to watch too much of Dick Harpootlian because he does a lot. And I think he wins this argument hands down because I don't think he has to make the argument. He really doesn't.
I mean, he basically just gets to stand up and be like, isn't it awful when like crime happens in court? And the court's like, yes, we don't like when our clerk crimes. That is bad.
It was the easiest job that ever existed. He didn't have to remember a case. He didn't have to remember a site. Now he remembered the trial of Aaron Burr, and the judge basically calls him out and says, "Stop grandstanding. Shut up. Move on."
He literally says, like, stop trying to have a man from all seasons moment. And I was like, or a man for all seasons moment. And I'm like, dude, they just kind of spanked you there because they're not wrong. You are totally showboating.
He was showboating. It was showboating. Now Creighton Waters gets up and he was immediately goes in and tries to sell this as something it clearly wasn't. Let's start with that.
Prior to deliberation, during the presentation of the evidence, with all of that going on, some jurors like, well, you know, I didn't know what I was going to do, but Miss Becky said, you know, watch his body language, and that made the difference. And I would submit to you that is simply not a finding that is justified in this evidence. It's not a finding that's justified under what we know about jurors, and it's not a finding that's justified by what the jurors said in this particular case. Now, to sort of detail my my analysis in my free 5 minutes that I have here before the question comes, is we have 606, and we've got two issues. We got number one is what happened. And then we've got number two, which is,
I love how strictly they followed time limits on this one.
And when we start with,
well, you mean by strictly as in like when he hits his 5?
Oh, when he hits his 5, they let him get about 6 seconds in before they start hammering him. But when he gets to 0, he's like, "Well, I'm out of time." They're like, "Nah, bro." Like, you're still on the hook, and you're going to be on the hook until we say, until we say otherwise. So, no, nope, you don't get to get out that easy.
Creighton Waters had a bad day. He had a real bad day because he had to
The thing
defend
is, he
something
knew
that,
he was going to have a bad day coming in.
yeah,
There's no way he didn't know where this was going.
no. And the bench was hostile to him. Well, let's watch. We're gonna watch when he hits his 5-minute mark because he actually does a pretty good job. He uses his time correctly here. For a trial lawyer, he was very good at appellate advocacy, I thought. Better than Harpootlian. Harpootlian was doing a closing argument. I was like, bro, why are you not arguing case law? Why are the justices having to feed you the answers? Like, do your job.
With what happened, that is obviously a credibility and fact-finding effort by the trial court. This court is very clear.
Side note, thank you to the trial channel. I'm pulling this off the trial channel because that was where I watched it originally. So thank you for that contribution. Please go check them out. Literally, it's just watching trials. That's it. So it's very easy.
That the trial court, because this is not like
Ooh, 1.5 is too fast. Sorry.
a trial. This is a procedure that is in the discretion of the trial court, and ultimately any credibility findings, fact findings, this court respectfully would defer to. And so to determine that, what exactly happened? And this court ultimately credited the 11 jurors. And so what do we have with those 11 jurors? We have one juror saying that Ms. Hill said this is an epic day and the defendant is going to testify. All right. And then we have another juror who says, watch his body language. And beyond that, the court clearly did not credit Juror Z. And I'll get into more about that, but there's plenty of the support in the record why the court could not credit what Juror Z said. Juror Z was ambivalent. Her answers were all over the place. None of the other jurors heard all those egregious statements. She couldn't even remember all of these egregious statements when she was on the stand. She said, I don't remember them. All of these things that really would take this analysis into a different level, she didn't remember. So when we boil it down to what happened, we're talking about epic day. All right, epic day. Everybody in the courtroom knew it was an epic day. That is not.
That pissed me off so much.
Everybody knew it was an epic day.
No, they don't.
You mean the jury shouldn't know shit?
The jury shouldn't know shit. Like, it would be absolutely a mistrial if the judge said, "Oh, the accused is about to testify. Jury, this is going to be epic."
Yep.
Can you imagine a jury, like a judge doing that?
Well, think about the opposite. Like, hey, jury, the DNA expert's going to be on the stand next. So have some caffeine at lunch because it's going to be nap time for everybody. No. Now, Creighton has to do what he has to do because every one of the statements, every one of the jurors says that Becky is saying things to them, which is a problem.
Yeah.
Creighton is trying to keep this this is a problem, but not a reversible problem. The problem is Creighton is picking the most innocuous of the statements that are reported. Like, he's not picking the big ones to go after.
It's rare for a defendant to testify. That on its face is a neutral comment. That is not necessarily a comment one way or the other. And if anything, we've seen where instances of a jury in deliberation considering the fact that a defendant didn't testify, saying, he must be guilty because he didn't testify. That's actually been an inference that goes more in favor of the defendant than against him, the fact that he's testifying. But again, it's rare that a defendant will testify. That ultimately is a neutral statement as well. And then watch his body language. Again, that is what was found. Not don't get fooled by his comments or anything like that. That was not what was found by the trial court. Just a neutral comment of watch his body language. And so that is the facts.
That's not a neutral comment.
So when we move on from there, then the analysis is how do we analyze that? And first of all, we have the discussion of whether or not there's a presumption of prejudice. Justice Toll, of course, found based on this court's clear case law that there was not. But I would agree. I would submit to you that not only because of the alternative findings, but just because of a general analysis that
this is how you know he's a trial lawyer. See how he moves away from the microphone? Appellate lawyers are really damn good at staying right in front of the microphone. Trial lawyers are notorious for moving. I move around like fucking crazy. And every now and then I get not yelled at, but reminded by the court if I could please stay still.
Yeah, that is the thing.
You have the burden. That presumption of prejudice was overcome in this particular case. And I'll talk more about that in a second. But
also, appellate lawyers,
legal analysis,
trial lawyers, for moving away from the mics.
Yes.
Because the number of times that so when you're doing an appeal, it's based entirely on the record. And so if you end up with a record that is, tainted because the lawyer moved away from the mic.
And wouldn't you say that it was just about then that you saw that And then you came back and you saw the body.
Or you've got the, you know, like the lawyer says something clearly objectionable, and then it's like, objection, but the objectionable comment never made it onto the record. It's like, so what was the objection? And unless there's a speaking objection, it's difficult at that point. So,
yep.
Think is going to be dispositive because of the relatively non-egregious nature of these comments. They are nothing like the comments that were in the cases that have led to reversal. So let's talk a little bit about more of the findings that were there.
Watch
you
his
can
clock.
hear him kind
Steve?
of.
Well, he hit his 5 minutes. I think this was he actually ends up hitting. I think that was the end of his opening monologue. That was what he wanted to get through. And then he says, and let's talk about more of what we have. That's him moving on beyond what he has his planned 5 minutes.
Yeah, you can hear him start to stammer, but they let him get very, very, you know, very little out after this.
Yeah. This was a good question. Why are Putin Waters doing the arguing instead of the appellate lawyers? One, for Murdaugh's team, I don't think Murdaugh can afford appellate lawyers. I think that his trial lawyer is all he has. For Creighton Waters, I don't know. Maybe he's that invested in this case. He does a good job. He does a damn good job defending the indefensible.
I mean, I don't hate the work that, you know, as much as I mock Poot, I don't hate the job he did. Now, I mean, he was lawyering on easy mode, right? Because these are the kinds of facts you dream of for an appeal.
I mean, you have the entire Supreme Court, or you have the Supreme Court panel, and every one of the justices is like, wouldn't you agree with me if I said this? And you're like, why, yes, I would. Wouldn't you agree? Like, talk about a good day. Like a damn
Wouldn't
good
you
day
agree that this conduct was egregious and requires reversal? Yes, Justice, I do agree those things.
You took the words right out of my mouth. and then Creighton gets up there and he's like, I'm going to try and sell you a shit sandwich and I'm going to hope to God that you're not as perceptive as I know you are, even though I know this could be a bad day for me.
I mean, the only way this could get any friendlier is if they ask something like, and did you notice that opposing counsel has like toilet paper stuck to his shoe?
It is brutal. It is absolutely brutal. Now, one thing I will say about Creighton Waters, of the prosecutors that we have seen recently, I was critical of him when we watched the Murdaugh trial, but as far as I was critical of some of the theatrics. For example, I hated his last line with every fucking witness. Did you know Alex Murdaugh? Did you really know Alex Murdaugh? I hated that. I hated it. I thought it was stupid. I thought it was irrelevant. I thought it was prejudicial. I thought it should have been stricken. I think it never should have happened. But as far as effective questioning, he knew this case backwards and forwards. And
well, the other thing is he did about as well today as it's possible to do with these facts. Like he was ducking, he was weaving, he was, you know, he's like, well, let me reframe this. And the panel's like, no, but good try.
In looking at the evidentiary hearing that was done,
everybody.
We had, of course, Ms. Hill testify, and the judge found that she was not completely credible. We had Ms. Rhonda testify. The court did not credit that testimony because Ms. Rhonda conceded over and over again that she absolutely heard nothing whatsoever.
Mr. Waters, I'm going to stop.
Holy shit.
You see, he gets 6 seconds over the time, and they just are like, I'm going to stop you.
That is wild. That is wild. Like, now here's the thing about this. Some people confuse this for being, and I saw some comments about this a little while ago, the reference to what a hot bench is. some people confuse this for disrespect. No, this is our like battleground. We love this. Give me the questions. Fight with me. Let me fight back.
The worst
I
bench
hate
is the
island
cold
judges.
fish bench.
I hate
where
it.
you just go up. And the thing is the cold fish bench usually means you're going to lose, and that they think your argument is so bad that they don't even want to give you a shot at fixing it. And I mean, sometimes you have to run those appeals, right? I had a client, he wanted to appeal, and we filed the appeal. And the day before the appeal, the appeals court heard basically the same issue and ruled against it. So I walked in and I was dead in the water. But, they're just like, how do you go through this? How do you deal with this case? And I sort of tried my best to say how it gets distinguished. And the court was like, okay, you have 20 minutes remaining. And at that point, I knew I was done. Like, I'm cooked. But I just talked for 20 minutes, and then they said, thank you, Mr. Runkle. If we have any questions. And I was like,
this is a really great question. So Sarah says, I don't understand the 5 minutes. Doesn't he have 15 more? This is a wonderful question. I'm really glad you asked it because we get to now explain it. Oral argument in appellate cases is not what you normally perceive it to be. And generally speaking, the 5 minutes things, this is relatively new. The U.S. Supreme Court, under Justice Roberts, has a 2-minute opening. So you're allowed to have 2 minutes uninterrupted before the justices are allowed to start peppering you with questions. That was a new thing because prior to Justice Roberts, there was no time restraint. So some lawyers would get up and begin to start saying, good morning, Your Honors, may it please the court. And then immediately a justice would cut them off and start asking questions. Because oral argument you would be confused by thinking that it's there for you to persuade via your persuasive monologue how the court should perceive it. No, it's not. It's for the justices to walk up there having read your briefs. It's for them to probe the strengths and weaknesses of your argument. So, of course, your best argument is going to be written down on paper when you've had all of this time to prepare it. And it's going to be, it's going to have this really shiny, pretty exterior. It's going to be there. But if you hit it with the right facts or the right analysis, is it going to crumble? Is it one of those things? Are there logical fallacies that underpin this? Are there certain things that, what are the unintended consequences of what you're asking this court to do? The justices are there to really test that argument and see if it does hold up to that level of scrutiny. And then it's also an opportunity for the justices to communicate with one another. They're communicating through you, through the questions they're asking. So they might think that the justice on the opposite end of the bench from them really believes that there should be a new trial, but that the evidence shouldn't be reviewed. So this justice now views it is their opportunity to ask as many questions about the evidence that show this other justice that they should reconsider their position. So, yeah. Go ahead, Ian.
Even when they don't formally give you 5 minutes, they usually informally will give you a little bit of time to start in. And I gotta say, one of the best, I have done moot court judging where you're judging students, right? And one of the best uses of that time, because we do the same thing in those moot court things where you're basically acting like the panel, but it's a student up there. One of the best uses of it was this student, and they got up. I tried to convince them that they should go into criminal law, but they were like, no, I want to do civil litigation. So I was like, damn it. But they got up and they said, Justice, I know I don't have much time before you're going to begin with questions, so I want to begin with where I sense my argument is weakest.
Wow.
And he just went in with here is where I think the weakness of my argument is, and let me try to argue better. And I was like,
wow.
Everybody goes in with their strengths at that point, right? Everybody is like, here. And I was just like, you son of a bitch, because I had all sorts of questions to ask him. And what is it? And I thought it was really good. So
that would catch me off guard. Like if I was the panel, that would really catch me off guard.
It caught me off guard. So I was just like, huh, that is really good. That is a really excellent approach. And I had to adjust my questions.
Robin, the ADR Pro, you have to learn that the judge who's giving you the hardest time may actually be on your side, and the judge who's nice may not. 100%. I had a case where I was arguing for 3.5 hours on a discovery dispute and whether certain privileges should or shouldn't apply. It was a purely argument of law. It was probably the most fun 3.5 hours I've had in a courtroom, arguing law and just law. And the judge that I was in front of was probably the hottest bench in Fairfax County. Like, where's the authority? Where's all of this other stuff? And hits you with statute and case law. And what he's doing oftentimes is he's testing you. He is testing you both on your knowledge and command of the law, but also he's testing you to see if you're actually going to admit when he hits you with something you don't know and how you respond to it. And he hit me with a case that I didn't know. And I said, Your Honor, respectfully, if you want to give me, if the court would give me an opportunity to review it. Now, having not reviewed it, I can't necessarily address the court's request directly. And my associate's next to me, and my associate reviews the case while I'm arguing, and he leans over as there's a pause in the argument, and he shows me the case, and he highlights this one portion. And I said, Judge, going back to the comment you made about the case, that 100% supports my position, because the quote here, and I start reading it, the judge starts nodding his head. And I was like, you son of a bitch. It was like a little trap door that was there. But I felt like I was maybe not losing, but fighting uphill battle the entire time. Opinion comes out, it's 100% in my favor.
I also saw one where a court, this was one of the funniest things I've seen from an appeals court, was the court was like, and do you think the case of, and they rattle off a case and a citation to this lawyer, and they say, and do you think that supports your position? And the lawyer goes, absolutely, Justice. And the justice says, okay, because I just made it up. That case doesn't exist. He's like, and I feel like you've been bullshitting me for the past 20 minutes. And now I have it confirmed. And I was just like, I was sitting there watching. I was set to argue my appeal afterwards. And I was just like, oh, man, that guy just got, yep. That guy just got smoked.
So Creighton Waters is entering the unenviable position of being probed with these questions. And I mean, they are coming in hot.
Since you're 5 minutes
if he's going to get probed any more thoroughly, it's going to be with an alien abduction.
You're saying these are innocuous comments, not to be fooled, and look at his actions, look at his movements. The court seems to believe Juror Z when she says in her affidavit and when she testifies that these comments were made to her. However, she goes on in her affidavit to say, not to be fooled, which I understood to mean Mr. Murdaugh would lie when he testified. Look at his actions, look at his movements, which I understood to mean that he was guilty. The juror is testifying in her affidavit that the effect on her was significant. Why can the court? How can the court find that certain comments that she made, take them and incorporate them in the order, but not believe what she says about the effect?
Well, two things about that. I think that, first of all, Justice Toll did not credit any of the egregious comments that she didn't even remember herself on the stand, such as won't get fooled. The only comment that was credited was what was testified by Juror P, which is watch his body language.
And let me, and I want you to finish your answer, but I want to ask you this. So far as the comments are concerned, are we limited, is this court limited to only the comments that are included in Judge Toll's order, or are we able to consider all the comments that are included in the affidavits, even the egg juror affidavit?
Well, what I would say to that is the case law is clear that the trial court has the discretion to conduct this hearing and ultimately make credibility findings, which under typical appellate law, this court would defer to. And so my argument to that is if you look at Justice Toll's order, both her oral order and her written order, she credited the 11 and did not credit Juror Z and did not give any credence to 741, the alternate, and or the egg lady, which of course did not testify. Now there was on page 808 of the record where she says, I think we've got in terms of what she says, Ms. Hill says, and what Ms. Hill says she says. That's on page 808 of the record and talking about the egg lady juror. But ultimately, I would submit that this court in appellate review does need to defer to credibility and factual findings of the trial court. And the trial court only found the 11 credible. And
well, then help us understand the ostensible inconsistency when the trial court finds portions of Juror Z's affidavit credible and just carves out and doesn't deal with the part that dovetails with the alternate juror's testimony, which is far more prejudicial.
Sure.
How do we do that?
Well, so we're looking for, I would submit from an appellate court's standard of review, we're looking for support in the record for those findings. And so when you look at Juror Z, okay, and first of all, you look at the 11, which you did credit, and none of those 11 heard any of these other egregious comments or anything like that.
What do we do about the order that doesn't even mention that Juror Z did in fact testify about the comment, "Don't let the defense confuse you"?
Well, I think that when you look at the order in her specific paragraph on Juror Z, what she says is that Juror Z was ambivalent, and ultimately, as she goes through the analysis of what Juror Z says, she's not crediting that testimony. And again, I think there's support in the record for that.
There may be, and that may carry the day for you.
Right.
Assume that we find that that statement was made. Do you still have a
every lawyer's worst fucking nightmare right there. Every
when the court says, assume that we find that this statement was made and that statement is bad for you, and what they mean is we 100% believe that this happened. We're just not saying that we have prejudged this, but this is what happened. This is what you have to deal with, and tell us how you're not fucked.
Yeah.
If
I
you know,
this one was one of the questions. You know, the Court of Appeals, it's difficult.
I was
to
hoping
read
you'd
in
cover this
too-
question because
too much. But this is one question that every lawyer who's ever sat in this position, every lawyer knows. I understand that you believe, but assume for 1 second that I don't. And you're like, all right, shit. Let's, and then the next one is get me over the finish line. How do you still win? If you are hanging a lot of your argument on this, if you are putting all of your eggs in this particular basket, so to speak. See what I did there? I thought it was very, If you are putting all of your eggs in this particular basket, let's say hypothetically, I don't buy that bullshit. Do you still win? And you pray to God that your answer is yes. Because
I mean, you should look at this like you're James Bond and you just sat down to press some person for information, and then just mid-conversation they say, assume that your martini was full of cyanide, Mr. Bond. What is the plan from there? You're like, well, shit, now it's time to go get an antidote, right? Because
Dub Fit hits it great. Abandon the basket. Yeah. It's this one was immediately just going, oh shit, he's pissed. He really does not buy this at all.
Path to victory.
That don't be fooled.
At the end of the state's case, before the defense presents its case, the statement was made. Do not be confused. Do not be misled by defense and its counsel.
Right. Well, I would say
the other thing that would scare the shit out of me, that justice was not reading from a piece of paper. He was not reading from a piece of paper.
He's got that memorized.
That was memorized. He is pissed. And that's the Chief Justice, I believe, right? I think so.
I'm not sure.
And this is like everything in this, it is a question of degree. Okay. And there could, if the clerk had come in there and held a gun to their heads and said, you better vote guilty or I'm going to shoot you all, I probably wouldn't even be arguing that's not structural error. Okay. But everything is a question of degree. I'm not going to concede that if those statements were credited and are part of the review, that our path to victory is not harder. But I think you have to look at that in the context of this entire trial and when those particular statements were made.
And I think context is important. We all can cherry pick some of these that are on the surface innocuous. Epic day, big day.
There's another one. He just literally accused Creighton Waters of cherry picking.
Yeah, cherry picking is one of those things that's like, oof.
And when viewed in isolation, they don't move the needle, arguably. But when those seemingly innocuous statements are considered in the aftermath of the originating statement, not to be confused and misled by the defense, those initial innocuous statements take on a very nefarious message.
I could not argue otherwise, that it would absolutely be a question of degree. However, I don't believe that that just ends the inquiry right there, because you still have to analyze it in the context of all of the factors and everything that went on. And so to look at that, let's look at all of the things, and let's assume that we're limiting to what I contend Justice Toll found, which again, when I say innocuous, I'm saying relatively not egregious. I'm not saying that the clerk should be saying watch his body language, okay? But that is a far different comment from what you're talking about right there. But even if we add that in, we're still talking about a limited number of jurors who saw that. And then we're putting that in the context of where that occurred. Okay, it occurred during the middle of the defense case, not during deliberations, not right before deliberations, but in the middle of the defense case. It occurred during, I think we counted no less than 60 times that this jury was told by Judge Newman to only rely on the evidence, to not talk about the case, to not have external influence and all the rest of that. And we have to credit that. We also have to, again, put that in the context that when and if that occurred, and even assuming that there was a one bit beyond that, that it was attenuated from the actual point of deliberation by the rest of the defense case, by the entirety of the state's reply case, by all of the closing arguments of counsel, and by Judge Newman's very detailed charge. And so while that would be different, I don't think that that is fatal when you look at the entirety of this 6-week trial. And again, go back to what I said ultimately at the beginning of my argument here is that for that to happen, you have to conclude that with all of that going on, with this massive evidentiary presentation, with multiple instructions from the trial judge, with all these arguments.
So you're distinguishing a 1.5 day long burglary third trial from this trial?
No, sir. But what I am saying is,
oh, that was a trap. That was so well placed too. It was, and you knew that he was going to go there with how big the expenditure and resource was, and you can't set this aside because this trial was so long and so significant and all the above. And that to that point, I pulled up objection 403's comment here. I went to the trial as well as the jury tampering hearing. I sat there and watched Becky Hill smile her way straight through her testimony. Shame on her. He absolutely should get another trial. That name needs to kind of forever live in infamy for that type of conduct. The trial, Creighton's point here is a solid point it's not a solid legal point, but it's a solid practical point. And the practical point is the amount of resources that the state put into this trial, the difficulty it was to hold this trial together for the weeks that they were putting it on, to seat a jury. For all of that to be cast aside because one person who was elected to her position, who was trusted by the people that elected her there to not fuck up, did the one thing you cannot do. Well, not just the one thing. Did one of the only things you can't do.
Yeah, I mean, it was really egregious.
Oh, she shouldn't have. It shouldn't be a Brady list, Catlin. This should be the Becky Hill. This should be pulling a Becky Hill.
Prison. This should be prison. Right? Like clear out Murdaugh's cell, put her in there, and Murdaugh might get a new cell when he goes for a new trial. Now, I mean, you're not actually going to put her in that cell because, men's prison versus women's prison, but she should go and put her in with Sarah Boone. Her and Sarah Boone can share a cell. I mean, they both like to write.
And you could have debates. You could have debates over as to whose writing is better.
I mean, it might be hard because after Sarah starts, or after Becky Hill starts cribbing off of Sarah Boone stuff and plagiarizing, how would you know?
Becky Hill writes a motion for new trial, literally copied verbatim from Sarah Boone's last letter to the judge. Forward in the next book by Becky Hill is written by Sarah Boone.
Oh God, that would be, I might actually buy that one. Like
I'm
that
not
one
lying.
could
I
actually
would,
be,
I would absolutely buy that book. I would 100% buy that book.
and just be like, can I get it signed?
Chris at M96, there's apparently a line around the building to get in and watch this, including Clemson and USC pre-law grads. Glad I didn't try going. Good. This is a phenomenal learning experience. This is a great learning experience. Watching this legal issue presented in this context with this panel, and to be candid, these very good lawyers, Jim Griffin, I mean, all Poots comments aside, he's a good lawyer. Jim Griffin is phenomenal. Barber with his reply was probably the most effective 5 minutes. He's the one I want to go to at the very end, because the reply is your opportunity to get the last word in front of the justices. And you get to play cleanup. And Barber comes in. He was my favorite lawyer through the entire trial. He was the expert lawyer. He was the one who examined all the experts. I loved him. So good for those law students. They got a great lesson that day. Annabelle Feinstein, Poot reminds me of the old me in the balcony on the Muppet Show. That you can't see it now. You're welcome. Oh, God. Harbinger of imminent death. The timer should be connected to a trap door. For Becky Hill? Yeah, sure. Mrs. Vicky, I believe there'll be a retrial, and I believe Becky Hill should have to pay for it. Unfortunately, the mechanisms don't exist to do that.
Is that I do think time matters. I do think,
but you would agree that at the end of a Berg third trial with a guilty verdict, the judge finds out that the clerk of court was back in the jury room saying something like, well, that defendant's not going to testify. But I just want to let you know, this is the 5th time he's been up here for a burglary third.
I'd be willing to bet a good amount of money he was a trial lawyer. How quickly that ran off his mouth, like how quickly it ran off the burglary third, all the remarks, I bet.
So I just want you to know that. Egregious or not?
Your Honor, if that were the case, I would be very hard pressed to argue otherwise.
Okay, so help me out with this. If we craft a standard based on the length of a trial, and heavens knows nobody wants to try this case again. How do we create a standard based on a lengthy trial versus a day-long trial when the constitutional right is the same?
Absolutely, the constitutional right is the same. And what I'm not asking is this court craft a different standard for a long trial versus a short trial. What I am saying is what is relevant to the ultimate inquiry that this court engages in is the timing of when these comments took place.
Okay, well, let's talk about that. And I'll weave in some questions about the egg drawer. Ms. McElveen, the Barnwell County Clerk of Court, said she didn't hear any of these comments made in front of jurors, but the comments made to Ms. McElveen by Ms. Hill were remarkably the same as those related by the jurors. For example, watch him closely, look at his actions, look at his movements. Ms. Hill was saying that to staff and to Ms. McElveen. You agree that's what she testified?
That's what she testified.
That does match almost exactly what these jurors said Ms. Hill told them, correct?
It is.
Okay, so explain to me how we pass go under your theory. How do we accept the fact that Judge Toll maybe didn't mention all these things in her order, but they were supported by an impartial witness, that being the clerk of court from Barnwell?
Well, two things about that. I don't think we can get past what you've recognized, that clerk of court from Barnwell heard nothing going to a juror, or she would have brought that to the court's attention.
But the consistency of the comments or the similar nature of the comments is striking.
Well, and then my second part that I would say about this is that all of this arose months and months and months after trial. And the courts have been historically reluctant because of that passage in time, because of the fact that jurors vote one day and one day only, and don't have to assent to their verdict and vote him guilty every single day for the rest of their lives. And so I think that passage of time is something that is relevant as well when this case is being talked about incessantly out in the world. And so I think that that's something as well that Justice Toll can consider in deciding what actually happened, and the best evidence of what actually happened, and whether or not it is whether you look at what the jurors said about it, not to get to the 606 aspect of it, or if you're objectively standing back and making that factual finding of this is what happened and this is whether or not there's a prejudicial effect. That is why Justice Toll credited those 11 jurors, and that is, I would submit to you, the realm of what this court needs to consider.
I want to ask you a question about this idea that you expressed, that this event or these moments when the clerk spoke to the jurors should be considered insignificant when viewed among the entire trial, whether it's a long or short trial.
there's no eyewitness, there's no DNA, there's no one thing on the part of the state that that you could rely on to show him guilty. So you had to piece together a whole bunch of different stuff. We'll talk about a lot of that stuff in the next phase. But you spent, most of that 6 weeks was you piecing together small pieces of evidence to put together an argument that he did it. On his side, now, of course, he doesn't have the burden and isn't even required to testify. But on his side, whether he's guilty or innocent boils down to one moment, one thing. And that's when Ellick sat up on the stand and said, I didn't do it. So what I'm wondering is, you're wanting us to consider the statements by the clerk to be insignificant, but those statements go to the only thing that the defendant really had. I mean, the defendant can argue that you didn't piece it all together, but really the defendant's argument boils down to the one thing that the clerk of court addressed. So we can look at all this context if you want to, but the jurors knew that if Elliott was telling the truth, he's not guilty. If he's lying, he is guilty. And that's where the clerk of court's statements appear to focus. How do you respond to that?
Well, I would say that while I understand that obviously.
I don't. It sucks. It hurts. Please stop asking me questions.
How do you respond to that? I'm going to go have a little cry, Justice. Can we pause my time for me to have a cry?
It was very important, the defendant taking the stand. It wasn't as simple as just getting up there and saying, I didn't do it. Okay. And while there was a long piecing together of all of that, the defendant's testimony was also very long over the course of 2 days. And so I don't think that you can just view the defendant's testimony entirely in isolation of this entire trial. I don't think any analysis has ever said that we're going to ignore the entirety of what went on. Certainly the defendant's testimony was important, but they had been raising all kinds of issues as to lack of motive, as to other possible motives, as to the boat case, as to the Cowboys, and all these other things along the way as well. Again, saying this is an epic day, saying it's rare for defendants to testify, those are all statements that everybody in that courtroom knew, everybody in that courthouse knew. So while I hear what you're saying, I think that you can't take out the fact that this was a complex matter with a lot of complex issues.
And, to the extent though that you've made some fine points about how we should interpret the statements. But if the statements, and Justice Kitchens was alluding to this, if the statements kind of collectively go to the point you should not believe him, to me it's hard to separate that from the critical issue in the case. But I want to bring up one other thing. You point out in the very beginning of your argument that the trial court here found that Becky Hill was not credible. Now that's a soft statement. That's almost like Richard Nixon or Bill Clinton, whoever it was, said mistakes were made.
Yeah, that was another one that made me laugh like out loud when I was watching this.
Yeah, that's them calling bullshit.
Yeah. There's another word we have for that, right? You know what the other word is?
Sometimes people are not credible because they didn't get a good look at what occurred. Sometimes people are not credible because they don't remember what they saw. Yeah. Here, if Becky Hill is not credible, it's not because she didn't see it. It's not because she doesn't remember it. It's because she's a liar. Is that right?
I would say that ultimately she said she was not completely credible. And yes, sir.
So there's only one way to Becky.
Just imagine your reputation in the legal community when you have a sitting Supreme Court justice in the state where you were a clerk, literally saying liar on the stand. People don't really appreciate this because we cast these words say liar a lot. And I was going to get to that. We don't usually say the word. Now, my clients will say it in the privacy of my office, or I'll say it when it comes to a particular witness after the fact. But I don't get up in court and call someone a liar in court unless I absolutely have the goods. And let me tell you how many times I've actually had the goods to be able to call someone a liar. I don't remember actually getting up and saying the word liar in court.
Very rare that you pull that
they've
trigger.
Misremembered. I will say they've exaggerated. I will say any number of things.
I think that I said things like, they have a casual relationship with the truth.
Yeah, I've said something like that.
But liar is a big one, and fraud is another big one, right? So you got to be really careful before you use those words, and you got to make absolutely certain that the judge or jury, depending on which it is, there before you are, right? So, yeah.
But to have a Supreme Court justice come in and say she is a liar, I was like, oh my word.
It's very
Still can be
rare.
not credible, and that is that she is a liar.
I think that Justice Toll did not credit parts of her testimony as she looked at everything. Now, she didn't specifically find that she is a liar, but ultimately she didn't credit that testimony. But what I think is important is that neither Justice Toll nor the state relies on Becky Hill. What we rely on is what is most important, and that is the 11. The overwhelming majority of these jurors who sat there and looked Justice Toll in the eye, who judged their demeanor, who judged their credibility, and who ultimately were clear as a bell that there was no sort of improper influence on their verdict. And when you look at these questions and you know, whether or not they went beyond 606B, ultimately they were questions about impartiality. And I think there's a distinction, and Justice Toll made this distinction that when she phrased these questions, first of all, she had the 4 exact questions that were in green, which I understand the footnote, Justice Hill, when you were on the Court of Appeals, but they were the same 4 questions from the record in State versus Green. So that was a reasonable set of questions to ask. I see I'm out of time, but
you premise your response that she relied.
Well, they're not letting you go. So he started talking, what, 25:03?
And I
We're at
love the
26:03. So 20, we're at 20 minutes. And then he goes on for another 15. Yep. Sorry, Ian.
I love that he's like, and I'm out of time, and the justice is like, tough shit. So, like, you're not done. You're not done until I say you're done. So, yeah.
Let me get to the 404B issues, Jim Griffin.
Later, that would have arguably exposed the extent of his financial misdeeds. Why wouldn't that have some relevance for 404B motive purposes?
Well, we have the benefit of extensive in-camera hearing, well, not in-camera, but hearing outside the presence of the jury, and where all of these matters were testified to. And Ms. Seconder said that on June 7th, she went to confront Alec about a windfall, things of that nature.
Or
I hate to use this example, but perhaps this looming cloud, storm cloud, so forth, would have given him motive to do harm to someone who was going to blow the whistle on, instead of,
that's right,
according to you, too many degrees of separation of murdering his wife and child.
Well, if there was evidence of that, and that's in the case law, yeah, if there were a threat to report, for sure. But none of that existed.
Was there any evidence that Maggie was getting wind of these financial misdeeds? She did have a bounce check or two, right?
Yeah, I believe she perhaps.
Was there any evidence that she was going to confront him about money?
None whatsoever. None whatsoever.
And Paul, who's described as the detective, was there any evidence that he had any information about his financial misdeeds as opposed to him hoarding pills?
No, Your Honor. It was only his drug use Paul was wearing.
I want to branch off for a moment. On page 6,340 of the record, Mr. Waters was cross-examining Mr. Murdaugh. And if you read it, it is very, very compelling cross-examination.
Let's go to Creighton's response.
All it took. And they did that demonstration on the stand. And so the state, in reply, Satterfield was one of the factors in the gathering.
Sorry.
Relevant. And we streamlined this inquiry intentionally. And the defense.
This part, hang on.
Mm-hmm.
How was he and his son was allowed? Unlike the federal counterpart of 404B, our case law has said that our version of 404B is a rule of exclusion, not inclusion. Right. And the gate here was just left open. And I couldn't find any example of financial crime evidence that was excluded.
Thank you. The Chief Justice of the Supreme Court in South Carolina made me feel vindicated, because I was screaming and everyone was like, Judge Newman is the best in the whole wide world. I didn't have a whole lot of issues with Judge Newman, but I thought his rulings on this were 100% wrong. 100% wrong. I could not believe that he was allowing the dog and pony show of bad man does bad things, is bad person, and therefore guilty of murder. And this part was probably one of the most egregious. And I love that Creighton tries to defend it, but everyone in the room knows.
And the granular detail and the expansiveness of which everything under the sun was allowed is arguably problematic. Even the nature of the victims. There are many examples here, and I want you to respond. So I'll just share one. I think his name is Tony Satterfield, was testifying. Well, we had to hear about the disabled brother. How is that relate to motive evidence? That appears to be that not only is he a thief with a motive for murder, he's a despicable, low-life character. I mean, the very evil that 404B is designed to prevent, and then ultimately 403 is the final safeguard.
Well, first of all, I'll say that this was never argued nor presented as propensity evidence. And frankly, this court has recognized, and other courts have recognized, that the less likelihood of propensity when there's a vast difference between the type of 404 crime and the crime it issued. You know, once a stealing white collar lawyer, always a wife and son murderer. That's never was the inference and all the rest of it.
Sir, the trial lawyers in the room would like to respectfully disagree with you. Like, we know better than that. Like, we know exactly why you want this in. And it's not to give the background innocently that you think. It's because you know how jurors think. You absolutely know how jurors think. You're muted.
There we go. I think, yeah, they want it in because it's insanely prejudicial.
Yes, you absolutely like. Don't piss on my leg and tell me it's raining. I know you want it in because it's prejudicial. And this is one where I thought Creighton Waters, this is where this comes down on him and him only. This was his choice. He ran this case this way. He ran down that risk, and he had a trial judge that was going to let him get away with it. And he didn't stop to think. He didn't stop to think, oh shit, am I going too far? Am I opening the door for some appellate court to take an issue with how far I took this? Because the appellate court's going to give you a lot of latitude because they'll give the trial judge a lot of discretion. But
I think the
they start
appellate
to
court
see
would have
it-
let this slide if not for the Becky Hill shit.
I think so. But it's the combination of the factors where the Court of Appeals is going to have the opportunity to remand this, and they have the opportunity to remand it with instruction
On multiple things now. Like they might not have wanted to tank the Murdaugh conviction on just this, but they're tanking it anyway, so they might as well get in everything that makes them upset. So I feel like that's kind of where they're at.
That's fair. I think at the very least, like, Creighton Waters did not have to do this. Not to this extent. Now, what he did guaranteed a pretty fucking quick return by the jury on a guilty verdict. But it might result in a new trial that is going to be really expensive.
You know, none of the jurors were constipated based on how fast that verdict came back.
Yeah.
Because if
Also,
anyone was stopped up, that would have taken longer.
They went back to the jury room and they were like, hey, do we want to have meal here or meal at home? And they were like, meal at home sounds good. We'll just hang on and we'll just hold off voting and we'll get out of here and get home to eat a meal.
Yeah, they didn't even want the free dinner. They're like, this guy's so guilty, we're not even going to stick around for a pizza.
So, I saw so many people making comments but he's a bad person. That's why you can't let this shit in. That's why you can't let that in.
Satterfield was independently relevant, and we streamlined this inquiry intentionally. And the defense made their general objection to the 404, but never did once we kind of crossed through that door. We presented all of the
Sir, nothing about that case that you did with the financials was streamlined. Absolutely nothing. We went on a side quest that became the main quest for a solid 6 or 7 days.
that in camera, never made any specific, like, limit this part, limit that part. We tried to streamline it all. The only reason Satterfield was a witness who testified specifically was because Satterfield was one of the factors in the gathering storm. Satterfield, of course, there had testified that appellant had reached out to him and that he had reached out to appellant in the months leading up to the murders. I think even in June of 2021, asking about the case and about the settlement. And Alec, of course, is lying to him and saying, yeah, I'm still working on the case. I'm still going. But the reality is that he stole almost $3.4 million and had spent it 2 years ago.
But what did one of the Satterfield children's status as mentally disabled have to do with any of that?
Well, I think that the point of that was just sort of the back.
That was a different justice asking the same fucking question, by the way. That's when you know you're like, that's a problem. Like, that's when both of them are chiming in and they realize you have not sufficiently addressed our concern with this question.
And they start losing patience with his like ducking and weaving.
Yeah, they start pinning him down.
Yeah, they're like, you can't just dodge all our questions, dude. Come on.
Yeah.
Interacted with them and how this was a family that was close to him.
Did the fact that the young man was disabled add to the fact that he stole?
I think what it added to, again, was we had a witness who was testifying for independent purposes. And that was just a background fact of the pressures on Alec, because he had taken this family under his wing, a family who had one individual that he had told, I'm going to help you, I'm going to take care of you, one of whom had special needs. He had spent all of that money. They're asking questions about it.
The sympathy directed toward the victims of the crime is not related to the motive. If he's a thief, and that was...
Both of those are against you. Both of them are piggybacking off each other, and they're not happy with it. And then you get Barber up.
And that's why that evidence that's why you had the mentally disabled, victim of a financial crime, which has nothing to do with the supposed motive of, I need to conceal something because I might get caught, right? It has to do with, you don't really know me. I'm a really bad person. And because you don't really know me, you don't know what I'm capable of. So please speculate that I'm capable of murdering my wife and my child. That was the purpose of that evidence. We didn't have whatever it was, 12 days of financial crime testimony just to prove the fact that he stole a bunch of money and might possibly have had some fear that he might one day be caught for having stolen that money. And then the speculation is, well, he wanted a distraction. And we can talk about why this would, the logical leap to, I'll just murder my family and be the center of attention, and how that's somehow going to get scrutiny off of me, obviously doesn't make a lot of sense. And I think he, more than most people, is in a position to know, given his background, that putting himself at the middle of a high-profile murder investigation is not the best way to distract attention from his own affairs. So I believe that's why that's the logical disconnect. And then the real reason that it's admitted is this trial theme that you'll see in every single witness who had a personal acquaintance with him. Every single one asked, "Did you know the real Alex Murdaugh?" And that's why that was admitted.
Thank you, sir.
If I could, I would like to speak a little bit to the cell phone questions that both.
Chief Justice was done. Yeah, I just looked at him. His face was like, "You can be done." So,
yeah, you could be done anytime, sir.
Yeah. So that's nothing really there. The remarks of the Chief Justice at the end, basically talking about the rogue clerk. I think everyone who's looked at this case and looked at how that appellate argument went, they are all of the same mind that there is very likely going to be a new trial. I am loath to predict what an appellate court will do, but that bench was not friendly to one particular side. And I don't know that given
says new trial, that has new trial all over it to me. I'd be very surprised if they did not.
One of the challenges too is that you see that, and the Court of Appeals, let's say they don't grant the new trial, they've set themselves up to kind of be required to. Some of the remarks made during the questions are, and publicly made, so egregious that so many people in the public have heard these things phrased by the appellate court judges, the Supreme Court saying, this is what was said. This is how terrible that is.
Honestly, if this doesn't get a new trial, it's like, what is the standard there?
Yeah. Yeah. And I see some people asking about Judge Newman. Can you put some of this on Judge Newman? Some of it, yeah, but I'm kind of leaning with Ian a little bit. This wasn't purely about the financial crimes as because there was some of the door opening argument. I guess you could have gotten there. It wouldn't have been my judgment call, but I think the Court of Appeals or the Supreme Court could have ignored it. They could have found enough in the record. I mean, look at the Take Care of Maya case. That opinion came back from the appellate court, and it was just like a misstatement of all the facts. Like it read wrong. But it was still, they had enough protection to issue the order that said reverse. Now, they could have done that here with the financial stuff and affirmed, but not with Becky Hill. Like, that dog won't hunt. Like, that's not with that. So I do think he's going to get a new trial, which sucks for South Carolina. It sucks for everyone involved. Becky Hill, a name that will live in infamy, as well it should. Absolutely should.
It's going to be hard to watch King of the Hill from now.
Just wild to me. So the last topic, let me swoop to this. New swoop. The last topic I wanted to cover was one that we haven't talked a lot about on the channel. It comes up from time to time, but it is Laura Owens. So this footage, and not really footage, but the audio is coming, was courtesy of the Justice for Clayton Eckert YouTube channel.
I like the AI.
It's really kind of funny. Laura Owens. Ian, you know the Laura Owens case. I know you know it pretty extensively. I know the broad strokes.
Do you want me to explain her thing?
Yeah. Explain. Let's do a little TLDR.
So Laura Owens is basically a serial pregnancy faker. And so she gets with one of the guys from The Bachelor. And basically he's doing realtor work. She reaches out and she's like, I'm also a realtor. And so they get together and they have a brief encounter where everything that happens is
above the pants, or not above the waist, right?
Above the shoulders.
Shoulders, that's right. Yes.
So anyway, she then says, I got pregnant. And he's like, how? And she's like, I don't know. And he's like, no. So her pregnancy claims are super. Oh, a client looking to buy real estate, whichever. She specifically gets to like be around him so that she can. Yeah. She then goes and, claims that she's pregnant, and he's like, this is super sketchy. So she brings a paternity suit and he fights that. And she's like, I want to dismiss the paternity suit. And he's like, no, we're keeping you in this. So they bring her in to have, for sanctions and whatever. And it is one of the weirdest trials ever because her lawyer is sitting there like baseball signaling to her while she's on the stand.
Gingras, right?
Gingras. And anyway, the court finds that not only did they not believe her, but that they actively referred her for potential prosecution for perjury. So when you say like it's super rare, and I say too, it's super rare for the court to be like, this person is lying. They went further. This person is lying, and I think that they can convict on perjury, and I recommend they pursue it. So she's now been charged with perjury over several lies that they think they can prove. And quite frankly, it seems likely that they can prove it. Like she testified that this ultrasound is her ultrasound, and it's not.
Like, it was a Google
it's
image.
Just not.
It was somebody else's.
So ultimately, this, like, and I said early on, I was like, Gingras is fucking this up. He should be offering to pay to walk away. They should be apologizing and dropping this because he's gonna run this in, like he's gonna run his client into jail, which is exactly what happened. So
better.
Now she is in shit over she's declaring bankruptcy, and that's turning into a shit show too. So yeah.
For anyone who's watched me, so I practice two areas of law: family law, bankruptcy law. I have made comments about bankruptcy, and one of the things I talk to about is that people very rarely go away for bankruptcy fraud. Bankruptcy fraud is a crime, but very rarely do you go away for bankruptcy fraud. But bankruptcy is the avenue. It is the window that the trustee gets in to all of your financial circumstances where they discover all of the other fraud, because you have to state everything under penalty of perjury. All of it, financial transactions, the amounts in certain bank accounts, the amount of your debts, all of it. And it's really funny how people who do shitty business deals end up filing for bankruptcy. And then all of a sudden, everyone else who's a participant in those deals looks at the bankruptcy and says, wait a minute, I thought you said something different when you were making the deal with me. Case in point, Real Housewives of New Jersey, 2 of them went away to jail because various mortgage fraud, because their bankruptcy schedules revealed that they did not have assets and income that they had told the mortgage companies they did when they went and got the mortgages. So as a part of every bankruptcy case, and Laura Owens filed a bankruptcy, she filed a bankruptcy pro se by herself, no counsel representing her when she filed the bankruptcy. Clayton Eckert, among others, filed an adversary proceeding to basically say, Judge, in the bankruptcy case, please declare certain of these obligations non-dischargeable because they were procured by fraud or some other reason. And Gingras says, you know what? She filed this pro se bankruptcy, but I'm going to help her out because I don't know why he's helped her out at every turn. But
I don't know.
He's going to join in representing her in the adversary proceeding. Why? I don't know. But he's clearly not going to join and say he represents her, generally speaking. In a bankruptcy case, one of the first big steps is a meeting of creditors. It is a formality. The trustee, who's appointed by the court to represent the interest of the unsecured creditors, sits the debtor down, the debtor gets sworn, and the debtor has to answer questions. Did you state all of your assets and all of your debts? Do you owe anyone any domestic support obligation? Are there corrections to your schedules you have to make? The trustee is looking for assets that might be available. It's a technicality. It's a formality. These meetings usually take anywhere from 3 to 5 minutes. But if there are creditors that are interested, they're allowed to ask questions too. The trustee is present. The U.S. trustee is allowed to ask questions. To give you an example, I am starting this at 4 minutes and 20 seconds because
you're a stoner.
Tracy Collins. Rob, motion granted to fully mansplain or EL 15 bankruptcy law as we listen through this. So lost. I will. We are 20 seconds in. Because 4 minutes and 20 seconds in, no, she's not a stoner. Thank you, Ian. I did catch that. It was a little bit late on the joke. But because after 4 minutes and 20 seconds, the trustee at the point of the case is done with the question. Trustee's like, all right, I've gone through the formalities. And now the U.S. trustee gets to ask some additional inquiry, which is not normal. Usually when the U.S. trustee is chiming in, they're doing it through an associate attorney, or they're doing it through one of their paralegals who's just asking some questions about certain statements they need clarified, about expenses that you've claimed or about assets that you've claimed, or there's a misstatement on there they want to see corrected. For example, when I've represented clients where they have these very massive expenses that bring them down below a threshold where they can file. Oh, thank you for translating, Tracy Collins. EL 15 is explained like I'm 5. I love it. I learned something new today. In certain cases, Chapter 7 cases, individuals have to make below the median income for the state where they live based on their household size in order to file. It's an eligibility criteria. We don't like people to get the relief because it's such a significant relief when they're making a crap ton of money and could otherwise pay back some of their debts. So we have a means test where they have to make below that median. And I have some clients where they have significant expenses because they might care for a child who is an adult child who's fully dependent, or an elderly parent, or a person who has a disability. They might have that care obligation. And the trustee comes and they ask in the committee of creditors, they say, hey, you've listed $3,000 a month as an expense for medical care. I need documents to support that. I'm like, cool, trustee, here you go. Makes it easy. This is not necessarily one of those questions. This is not a simple set of questions. Trustee comes in hot, and it gets entertaining real quick.
Want to ask any questions, Ms. Jaimo?
Yes, Mr. Haley, do you mind if I have, maybe it's 10 minutes? Is that too long?
That's fine. This is the last one of the day.
It was not 10 minutes. It was not 10 minutes. I did not hear that. Can I have 10 minutes? It was 40.
Okay, so Ms. Owens, I'm an attorney with the U.S. Department of Justice, the U.S. Trustee's Office, and we oversee these bankruptcy cases sort of as a watchdog. And I had gone through your bankruptcy documents, and I just want to ask you some questions about some of them. But before I do, I just want to make sure. So is Mr. Gringas that's on here, is that your attorney for the bankruptcy case?
He has been helping with the adversary proceeding, but he's not my bankruptcy attorney. No, I don't know pro se, but he helped me because I confused up some of the filings.
I can clarify that if you need me to answer.
Yeah, yes, please.
So there's an adversary proceeding that's attached to this. I represent Ms. Owens in the adversary proceeding, but only that, not in this main bankruptcy case. I'm obviously involved in the adversary part of it, and I've been communicating with Mr. Haley and his counsel as well. But I've not appeared for Laura in the bankruptcy, and I don't intend to if I don't have to. But I'm just on standby for now.
Okay, so so Ms. Owens, I'm probably going to end up.
Yeah, you don't get to have standby counsel, by the way.
And standby counsel doesn't get to nominate themselves. Standby counsel sometimes is a thing with pro se people, but the court will ask somebody to step in to be standby counsel. And I mean, I've been standby counsel. I've had the court, and sometimes it was literally just, Mr. Runkle, the next trial is pro se. Do you have anything this afternoon? No, Justice. Could you just hang around and be standby counsel? All right. And you do that because the court is going to very much appreciate it later. And, maybe we'll let you out of some shit when you screw up. But you don't just get to volunteer yourself. I'm standby counsel.
Oh, it gets better because the trustee is basically, the lawyer for the trustee is basically saying, I want to know, oh, did he really file a notice of appearance in limited capacity?
Ooh.
You don't get to do that. You don't get to do that. You're either in or you're out. This is going to get real good. Okay.
He's going to burn his career down over this person.
Hasn't he kind of already?
Well, I mean, there's always more fire available.
After this, noticing your deposition and formally asking you for documents. So that's something I should ask of you personally because you don't have an attorney.
That's a fucking problem. U.S. trustee wants to depose you. No, at that point in time, here's what I'm saying. Mr. Gringas is not standby counsel. Like he is now my hired attorney, and we can coordinate those questions through my arranged deposition.
Oh, Gingras also knows who I am.
Oh, God.
He got very upset about me on Twitter at one point. He was shit talking me, or was it Twitter or his blog, whatever. But I thought that was funny, where he's like, "It might be that guy Runkle," and it's like, glad I'm under your skin.
If he has any sense, he's getting the fuck away from this case as fast as possible. So, but he's not. He's apparently, I don't know.
Correct?
Yes.
Okay. So I want to start with, I see that recently you amended the schedules of your assets to include a couple of Bank of America's accounts and an E-Trade account. Is that correct?
Correct. I listed them in the wrong spot on my filing.
Okay. So what had prompted you to file the amendment? Were you just going over them and realized, oh, this is not in the correct place?
I believe that Mr. Tate had questions. He was assisting Mr. Haley, and he had questions. And so then David had helped me with making sure everything was in the right spot. So I guess,
Which also sets David up for some liability, because here's the thing. In bankruptcy law, there's a requirement that if you are an attorney who have assisted a client in the preparation of bankruptcy schedules, you have to identify yourself. Because there was a period that we were so concerned about these third-party bankruptcy preparers who were helping individuals commit fraud, that we started requiring people to disclose if they received assistance in the preparation of their schedules, so that we could, or so that the bankruptcy court and the U.S. trustee's office could go after those individuals who were assisting them. So this one statement is going to get Gingras in trouble. He doesn't realize it yet because I don't think he practices bankruptcy law or knows what the fuck he's doing. But this one statement is going to get him in trouble. And I see Secret Labs, Lauren Owens gargled wrong. If someone can become pregnant via the method that she thinks that she became pregnant, it is far more significant than that. And for those asking, Laura Owens, yes, she faked pregnancy and then faked an abortion of the fake pregnancy. And then we are believing she faked cancer, right?
I don't know, but I see somebody saying Gingras just appeared in an IAH case for Laura against a YouTuber. IAH, intentional
infliction of emotional. No, wait.
No, that. What is IAH? It's not popping for me. Anyway, apparently she's pursuing YouTubers. Okay.
For what? See, what's interesting about this is that
if it's the Faust trial, this could be injunction against harassment, right? Oh well, that earns special ire because people who are abusing those kinds of processes are kind of shitty. So yeah,
interesting. Battleborn Pride, Sarah, good to see you. Glad. Missed you too.
Re-amending the schedule.
Ms. Jaimo, I think you might mean Terry Dake.
Yes. Oh, I'm so sorry.
Okay,
I'm so sorry. Yes.
You said Tate. I just wanted to make it clear. Okay.
Yes. Sorry about that.
Okay, so having seen that you amended the statements to identify those accounts, do you have copies, or can you easily get copies, like electronic copies of the bank account statements for the Bank of America account and the E-Trade account for 2025 and 2024?
Yeah. Mm-hmm.
Okay, are those accounts still open?
The E-Trade one is that I think is the same as Morgan Stanley. I think it is. Is that I think Morgan Stanley owns E-Trade. I think that's what it should be listed under. Do you see that? It's like
I'm just looking at your schedules and it indicates E-Trade account.
Okay, then that's what I'm thinking of for the Morgan Stanley. I don't have like another. I know that's confusing what I just said, but I definitely do not have another bank account that's not listed. The E-Trade account. What was your question on that? I'm sorry.
If you can get copies for 2024 and 2025 of the statements.
Yes.
Okay, so that's not going to be a problem. So I'll be asking that of you in formal document request.
Yes, that's no problem. I can get that. Yeah.
Very good. And I see that you added that you have a potential tax refund of about $891 for 2025. Is that correct?
Yes, I think that was for 25.
And where did you come up with that figure? That precisely?
I did it on Credit Karma. I did like my taxes on Credit Karma, and they came up with that figure, but then I never got a refund, so I was just presuming it was.
I can shed some light on that. That's the Ms. Owens, that's the amount that's listed on the 2024 federal return that
That's a court-appointed trustee chiming in.
That I got from you. So it's I assume it's your testimony that you never received that.
No, I did not.
Did you file that timely? You filed that 2024 return when on or before the deadline, or maybe the extension deadline, which would have been near the end of 2025?
Yes.
Okay.
So speaking about the tax returns, Ms. Owens, will you permit Mr. Haley to share copies of the tax returns that you provided him and are going to provide to him with me?
Yes, absolutely.
Okay, so Mr. Haley, you have no problem sending those to me, correct?
I do not.
All right, thank you. All right. Did you have a CPA
That's a
or
trick
accountant
question.
or any financial, bookkeeper, somebody assisting you with your tax returns or not?
No, I just used Credit Karma.
Okay. And I see that in your schedules, you listed debt to Cherry Tech, and that's a lender for Innova Med Spa, correct?
Cherry Tech is a lender that I used for Botox and for like a skin firming treatment that I got. I don't know if they're with Innova Tech, but that's not what I used.
Wait.
Full sculpting was the one I used it for.
People will lend you money for Botox?
I didn't know that either.
It's like, please, sir, I would gladly pay you Thursday for a Botox today.
Or skin treatments. I did not know that either. Okay, apparently we're financing Botox.
you provide the place, the name of the place that did that.
If
as
you
well.
need to finance the
So you
Botox,
never
you can't
obtained
afford the
any loans from
Botox.
Cherry Tech based on services or products that you purchased from Innova Med Spa?
Not that I'm aware of. I mean, I've gone to a lot of places for Botox and procedures, but that's
I bet
not
you
why
have.
I did anything for Cherry.
Okay. So do you have documents that show, invoices, copies of that sort of thing, that will show the debt that you owe to Cherry Tech that you listed here in the schedules?
Yeah, I should.
All right. So those are also documents that I'm going to ask for in my formal document request. So, okay. And just be aware, please don't destroy any documents right now while you're in bankruptcy. It's crucial that you keep.
If the red flags are not popping off in this person's head right now, and the fact that Gingras has not come in and said, we're suspending this discussion. Like you can ask these questions formally. We're done right now.
Yeah, he may not be very good at what he does.
These are perjury traps. Every one of them. These are all perjury traps. They are all, every single one of these.
I
mean, making some choices.
Be asking for some documents, and even if we don't ask for them, we shouldn't be destroying anything right now.
Okay, yeah, I'm not.
Okay. All right. So on Schedule I, it indicates that you have zero income, so no income from wages or operating a business, correct?
Correct.
And so for what time period were you stating that you had no income for?
I mean, I haven't ever in my life had like a 1099 or W-2 job, but I've.
So for those of you who are doing the math, yes, she claimed a refund, got a refund of taxes that she did not pay. Now, is that possible based on certain credits that you can get and claim and business losses and certain things? Yeah. Also, one of the issues I have with a lot of the tax code as it exists right now, like.
But let's be honest. Really been supported by my
Is there a chance she goes for fraud?
I don't know. Perjury trap. What do you mean by that? She is getting her to say a whole lot of things under oath that she should not be saying. This means she is having her testify under oath to certain things where she doesn't have the document in front of her. I don't know that she specifically recalls it, but she's getting her under oath to say something. And then she's saying, give me the document. You can give that to me, right? No problem. Because she knows, the trustee knows that the document's not going to back up what she just said. For every
She's
single
pinning her
question.
down to a bunch of bullshit is basically what it comes down to.
Yeah.
And then once
And
you're nailed to that bullshit. Yeah.
Yeah. This is.
So never in your life have you received a 1099 or a W-2 from any business, including your own businesses?
Correct. Never.
Have you ever received any kind of tax form like a Schedule K-1 that indicates that you have a certain share of earnings from a partnership or an interest in an entity?
No, I know that the LLC, my family's LLC business taxes are filed on a Schedule C. So that's all I know.
But you are the owner of at least 4 entities that you identified in the Statement of Financial Affairs. You are an owner of at least 4 entities.
I think that I would consider it to be like 4 I was associated with. Maybe David could offer some clarification because he helped me answer that question. David?
Well, let me just pipe in here. Either Mr. Gringas represents you or he does not. So I'm not.
Did you see what was happening there? They were like,
yep.
I want the lawyer to help me. And they're like, no.
We're not doing that. Either he's in or he's not.
Yeah. He's not your lawyer. So, no.
God, so great. The lawyer, she is so, this is great.
Comfortable with having Mr. Gringas step in as your counsel, so, if he's not.
I also love that she says his name wrong because doesn't he get super pissed off when people say his name wrong?
Yeah, but I can't remember what his name is supposed to look like. So.
Not your counsel here. Unfortunately, no, he cannot be, advising you on how to answer that. I guess, do you have a copy of your Statement of Financial Affairs in front of you?
I do not, but I have always thought I was the manager of LLCs, not an owner, and I have not ever filed them on my taxes or anything.
Okay, just because I want you to be aware that if you look at your own statement that you filed under oath, you check off the box that you are an owner of at least 5% of the voting or equity securities of these 4 entities: Quartet, Lizmax, Keybacker, and Stylet. So is that incorrect information that you put on there?
I thought it was if I had been known to have any like identity with those, and I knew they were ones that my name has been
The instructions literally say if you own 5% or more. Literally.
associated with over the years, and I was trying to cover my bases.
I mean, she's not good at
in terms of
instructions.
listing which ones I've been a part of.
Okay, and also I looked at your LinkedIn account, and it indicates on the LinkedIn account that you're an owner and executive with those entities. Is that?
I mean, they're really not comparable. I mean, I'm trying to market myself as an entrepreneur, but it's not like I've got these.
Let me tell you how many times I've ever had a trustee look at a fucking LinkedIn account. Never. Never. This case is now special.
Businesses that are
It was very special already.
Okay, I'm not asking yet about whether they're operating. I'm asking about whether or not you are an owner, and you hold yourself out to be an owner of these entities on your LinkedIn account and on your sworn schedules in this case. So, and now you're saying you're not an owner. You were just, well, I don't know what you were. So were you an owner of the 4 entities?
I mean, I'm more like, they're my family's entities, and I'm more like the face of my family's entities with those businesses, I guess.
Okay.
I mean, you're the owner or you're not, right?
Say
So
that. I know I'm not answering it well. I'm not trying to not be truthful. I genuinely don't know how to explain it.
Okay, well then you'll have to make sure, I'm going to recommend to you that you go back over your schedules, that you sign up for penalty of perjury and make sure everything's accurate, because you have in your sworn schedule stated that you are an owner of those entities.
Okay, I will go back and reevaluate that. I'm sorry.
Okay. All right, so on Schedule I, which is where you were supposed to list your income on the bankruptcy schedules, you added a line item on 8H for family support for food and living expenses, and you put 0. So was that a mistake? Do you receive any kind of family support to pay your expenses, your monthly expenses?
They just pay them out of their money. I don't, out of my parents' pension and Social Security. They don't give me money to pay that. They pay it directly.
So what are they paying directly when you say they pay it?
Well, I live on their property, so I mean, you could technically say they're paying, housing and for my food.
Okay. What about your car payments?
We share a car. They pay for my car.
Okay, so they directly, because you are the sole owner of.
I'm the sole owner, but they're paying for it right now because I can't afford to make the payment.
Okay, so that's something that you do need to specify how much it is, even if you have to come up with an estimate on Schedule I of your schedules. You have to indicate how much money they're fronting for you for your expenses.
Okay,
let's leave it 0.
Okay.
So you'll need to figure that out and amend Schedule I. Okay. Okay. So, and I'm assuming your parents also pay your car insurance?
Yes.
Okay, so you don't pay any bills for yourself?
No.
And you say that are you saying that you've never earned any income on your own, ever?
Correct.
Okay, how old are you?
Love it.
It's great. Oh God.
Never had made any income on your own to pay your own bills.
I mean, like I said, I'm the face of my parents' businesses, so they've, paid my living expenses in exchange for me helping them.
Okay, so that's kind of a compensation for your services, then.
I mean, I don't take advantage of it, but.
Oh God.
Well, you're providing them with services, and they're compensating you by paying your bills, is what you just said, right?
Yeah, exactly.
Well, then you better figure out how you're going to want to disclose that in these schedules, because that is a form of compensation. I would really read through what the schedules and statements require you to disclose.
Okay.
And we'll go more into this because I'll probably have to take your deposition, but I wanted to make sure to give you an opportunity to amend anything that you were contending was just an innocent mistake. Okay, so the biggest issue I had was that, regarding this claim report yours that you don't make any income. So you are aware that on the Statement of Financial Affairs, you did not disclose receiving any income of any kind for 2023, 2024, and 2025 through the date of the bankruptcy filing. You're aware you did that, right?
Yes, I didn't understand how I was supposed to say if my expenses.
This is about to get really, really, really uncomfortable for her.
Mm-hmm.
Sort of thing.
I mean, it's already really uncomfortable.
Right now, on the Statement of Financial Affairs, on items number 4 and 5, and you could take notes if you want so you can follow up and look you know,
Okay.
for this.
I don't have a pen, but I have my phone here. Sorry.
Yeah.
Which schedule is that?
So it's not the schedule, it's the statement of financial affairs.
Mhm.
And you've recently amended it. So it's items number 4 and 5. Required you to disclose all income you received, even if it was non-taxable income.
Okay.
There's 2023, 2024, and 2025 up through the date you filed the bankruptcy petition, okay?
Okay.
So I guess let me ask you, does your 2024 tax return indicate that you received any type of taxable income at all?
No. I know I was under the limit, but I just thought I had to file it anyway.
So what do you mean you were under the limit? Under the limit? Are you
For like, I know there's like some, if you make below a certain amount, you don't have to file, but I thought I did need to file anyway.
Okay, but so it wasn't zero though. So you might have been below the threshold for there to be a tax, but you did make some money. Is that what you're saying?
I mean, not to me. I mean, if you're going based on what my parents paid for, then yes, but I didn't make $1 last year.
I'm talking about now 2023. It's probably 2023.
In 23.
Yeah, but in 2023.
It was the same situation.
Okay, well, I guess I'm a little confused because so your testimony is that in 2023, and you're saying now under oath that you made
The amount of times when a lawyer says, and you're saying now under oath, and your testimony is, and when they repeat that another time, and when they perhaps
that's
repeat
brown
it again,
trousers time.
that is I'm about to get hit in the side of the face with a prior statement, aren't I? Or a document.
I like the way
that
I
says
put
I'm lying. Yeah, brown pants. Yeah, it's not. Yeah. Celebrial says $800 tax with no income is really sus. It is. Bis for Bob says she really doesn't know about being an owner, but her ability to cite tax filings is amazing. Isn't it interesting how she knows how Schedule C and the businesses work? KRAB 1791 Gingras is a self-styled internet lawyer. That is, if he still has a license after ERA, the Arizona gets done with him. It's going to be fascinating.
It's really interesting how there's these internet lawyers who, you know, they say I do internet stuff, and then they're just like awful at everything.
Oh, chat! Don't
there's a
spoil
bunch
it for
of them
everybody.
around.
I can see chat spoiling it. Stop spoiling it. Stop. Let her bring the receipts. It's so much fun when she brings it and lays out the receipts.
no income whatsoever in 2023. Is that what you're saying under oath right now?
I think maybe I don't quite understand what the question is, because it goes back to the LLCs with my family and and just how I'm understanding the question. All I've had has been they've compensated me by paying my expenses, and so it's been the same. So nothing has changed. I just want to make sure I'm answering it correctly, but I'm not sure I am.
Okay, you were asked on the statement of financial affairs to disclose all income, whether it was taxable, that you received from employment or from operating a business or from any source really whatsoever. And that would actually include gifts. You declared zero for 2023. Is that a truthful statement now that you're sitting here under oath? I just need for you to tell me if that's still a truthful statement.
Are you referring to, like, if they gave me a certain amount of money, then is that what you're referring to? Because there was nothing like tangible like that. They didn't, say here's $10,000 and that would be income. I mean, like, my bank statements will show. It's not like I had anything in there.
Yes, she has now seen the red flags after they were paraded in front of her 9 million times. And after she has walked herself into a perjury trap, she now sees the red flags and is now not answering the question the way the lawyer wants her to answer the question. So the lawyer is going to start being a little bit more aggressive.
In there.
Well, I guess I'll have to see your 2023 tax returns.
Oh, yeah.
Did you declare any income at all on your 2023 tax returns?
No, not that I can recall, unless I was saying that my parents, like there was an equivalent to what they were giving me, but I don't think I did that.
Okay, so I'll follow up with that in deposition, but I do need to understand, you're saying that now, but are you aware that what you're saying right now is completely inconsistent with the testimony you gave under oath in the Owens versus Eckhart paternity case?
And there's the trap door.
Yeah, and when they start asking, those kinds of questions, you're already screwed.
Yep.
And when have you ever seen a bankruptcy trustee go this hard on somebody? Like, this is basically, she chose violence today, and I'm here for it.
Once or twice, like I've seen it where I think there's some bankruptcy trustees who are like, it's a very collegial bar. They're not very aggressive. They're not very litigious, but there's some, the U.S. trustees office, they get some of them that are really good with numbers. And they really hate when they see what they believe is fraud. Really hate it. This lawyer's good because she did all the groundwork, laying out trap. Here's a trap. Here's a trap. Here's a trap. Here's a trap. And it's like, here, we're going to do the rug pull. See how she responds. Now, any person, well, the reason why you pay a lawyer is the lawyer sees the traps being laid before you do. So they're able to say, we're not talking anymore. And then they suspend, they walk away. They say, I'm going to talk to my client. I'm advising you not to answer your fucking questions. We deal with a different day. We might have to answer questions at some point, but we deal with a different day.
Yeah.
But she has
and
just
maybe a day when the client is like prepped for this.
Yeah. This is a disaster. Because now it gets really, really bad.
Are you aware of that? Yes. Are you referring to? Can you please explain?
More specific? Absolutely. So you were deposed in that paternity case on March 1st, 2024, correct?
Correct.
And in that deposition, you testified under oath that in 2023, you and your mother received about $83,000 of total income from the podcast. Nobody told me.
Mm-hmm.
You recall testifying to that?
I
do you recall testifying to that? Yes or no?
Yes.
Okay. So was it true when you said it then?
The podcast was making that much money, yes.
Okay. And in that testimony, you said you received half of that. So that's about a little less than $41,000.
But it was something that, I mean, our businesses have been such that we paid the expenses out of like what's been taken in. So it's gone right out.
Right. I understand. And so you would say that there was no net income. Is that what you're trying to say?
Yes. We had huge losses from the businesses. Yeah.
Okay. Regardless, on the statement of financial affairs, it told you to disclose all gross income, not net income. And you did not disclose that for 2023.
I'm not sure it made that in 23. I think it was like 23. In 23, I know I testified that, but I was thinking of the previous years. It definitely didn't make that in 23.
No, you're incorrect. Let me correct you. In 2024, you testified, and the question was posed to you in 2024: how much money did you make from this podcast in 2023? And you testified under oath that in 2023, the podcast generated $83,000 of income, of which you received half. That was your testimony under.
I like what I was entitled to if I needed to touch it or if I needed to do something with it. I mean, again,
how did she make $83,000 on her podcast?
I'm trying not to answer anything I don't understand.
Okay,
like,
well, again,
I gotta step up my grifting game if she was making 83 grand.
Well, she does the fallback of, I don't understand. I'm not trying to be evasive. I don't understand your questions. You understood really well every question I had until I came to this point.
What I was entitled to if I needed to touch it or if I needed to do something with it. I mean, again, it comes back, I did not understand what the questions were, and I'm trying not to answer anything I don't understand.
Okay, well, again, I'm going to remind you before we meet again for a deposition that I'm going to have you come to my office here. You might want to consider going over your answers to the statement of financial affairs. Hold on. Okay. Because you're supposed to disclose all gross income from 2023, 2024, and 2025. Also, when you testified in your deposition on March 1st, 2024, you testified that your horse business, and I believe that's Ortet.
How can she afford horses?
But they're the parents' horses, Ian. Just wait.
Yeah, my parents' business is Quartet Farms. I'm a manager of it.
Yes, but you hold yourself out to be the owner of that on LinkedIn, correct?
As the manager. I mean, like I said, so much of this is just semantics, and I don't know what I'm talking about. And I'm not trying to be dishonest or like hype.
Right, but you understand that what it means. There's a difference between a manager and an owner, and you use.
I didn't know that. I didn't know.
On your LinkedIn.
You didn't know that there's a difference between
a manager and a member on LLCs. I didn't know what the difference was.
Right, I'm talking about your LinkedIn profile. You hold yourself out to be an owner of Quartet. Is that not true?
Correct.
Correct what? It's not true that you lied on LinkedIn?
I mean, it's
Is that correct?
LinkedIn.
Say
Everybody
lie
on LinkedIn is lying, but
I will remind you, the trustee was like, I only need 10 minutes.
LinkedIn?
I think I didn't understand what my title was, so I guess technically, but it wasn't something that I'm trying to, it wasn't like I deliberately said that. It's my family's business. I think of it as like my family's company.
All right, well, the question is, you state on your LinkedIn profile that you're an owner of Quartet. Is that true or not?
Then I guess now when I'll change my LinkedIn, I didn't understand.
Okay. So anyway, you testified on March 1st, 2024 that the horse business, Quartet, made $144,000 of income, and that was split between you and your mom. Do you recall testifying to that?
That amount was made, but probably $400,000 in losses.
Okay, that's not what I'm asking. You gotta listen to my question. I asked you, do you recall testifying that you and your mother split $144,000 of gross income that was generated from the horse business in 2023?
I mean, I don't feel like I'm answering these questions the correct way. I mean, it's just that never
correct.
The only correct way, Miss
Owens, the bank account, it like didn't go to me directly. Like, yeah.
The only correct way for you to answer is honestly. Okay, so
that's what I'm trying to do is answer as honestly as I can, and I don't know.
No, you're not.
That you're asking me the answers to my family's businesses, and I don't know.
Okay. Well, that.
Oh, here comes the crying. Here comes the crying. I feel like I should sound more sympathetic, but I don't, because realistically, this woman has lied more in more legal proceedings than I can care to recall.
I don't feel that I should be sympathetic at all for any reason. And so I wish I was there to choose violence, but yeah.
That is what you testified to under oath in your deposition.
Just gonna have to live vicariously.
We'll have to deal with that later, but that is extremely at odds with what you testified to under oath in your pleadings in this case.
Correct, because I presumed that was like what my equivalent would be in terms of what I had done and brought in for work.
Okay. The other testimony that you gave, which is actually at trial in front of a judge on June 10th, 2024, you testified in front of a judge that you were at the time of trial, 2024, making $200,000 a year approximately. Do you recall that testimony?
Correct, yeah.
And now, was that truthful testimony?
I'm not comfortable answering that now that I realize how much I have messed up my other answers, and I want to speak to an attorney before I answer.
She's said all fucking day.
Now you want to talk to a lawyer, huh? Well, that would have been a good idea. Like, before you opened your mouth.
Because I genuinely don't know how I'm trying to explain that income has been split up in my family.
Okay, I'm just asking if at trial you testified in front of the judge that at the time you were making about $200,000 a year. And I'm just asking if that was true.
That was exactly what I thought of at the time. I mean, I know what the business is generated, so.
But you didn't report that on your bankruptcy, your sworn bankruptcy.
But that's what our family's business is generated, and I have been like the face of the business, is doing a lot of the work. So that's why I said that amount. I mean, I still know that was consistent with what they made, and that's why I said that amount.
Okay. Well, again, we'll have to go into this more in a deeper way when you come here for a deposition. So are any of the entities, well, let me just go by each one. Quartet, is that still operating?
Yes.
And is Lizmac still operating?
No, that needs to be closed officially, but it's not. Property was forfeited.
What about Keybacker? Is that still operating?
No.
And Stylete was never operating, correct?
No.
All right. So, but Quartet, that's the overselling business?
Mm-hmm.
Yes?
Yes.
And that's still operating?
Yes.
And do you still work for that entity?
That entity is not doing anything actively right now.
All right. So you're saying.
What a very odd way of answering that. The entity is not doing anything for actively now. Like, is it doing anything passively? Like,
Yeah. Is it? Oh
Does
my
it
God.
exist? Oh, no. This is a misconception. You can't just drop the bankruptcy.
She's stuck.
Now the trustee has because one of the consequences and one of the reasons why there is the ability for the trustee to go in and prosecute bankruptcy fraud is that you don't necessarily have the right to just say, I don't want to do this anymore. The trustee can say, I don't buy your bullshit. I either think there's assets somewhere that you're hiding and they go after those assets, or they say, I'm going to prosecute you, or they say, I'm going to enter and go after a dischargeability claim to basically say that you cannot receive a discharge. You are barred from forever receiving discharge in any bankruptcy at any point in time until the end of time.
She's basically got her metaphorical dick in a bear trap right now, and you can't just get it out that easy just because he wants to.
Yeah. I tell clients this all the time when they come in. I want to file bankruptcy. It's not that fucking easy. Like, be careful.
Saying that these businesses, these LLCs, there were no tax returns filed individually on behalf of them. Was there or no?
Liz Max, yes. The other ones, the other two you said were Keybacker and Stiley. Is that correct?
Yes.
No, there were no tax returns. Those never got off the ground.
What about Quartet?
Quartet, my parents file on their Schedule C.
Okay. So schedules, your parents are the ones that file on their Schedule C. They have the income Quartet flow through to them on their own tax returns. Is that what you're saying?
Yeah, nobody told.
If she transferred assets to her parents, the trustee sues the parents and gets a judgment against the
reverses
parents.
those transfers. Yeah.
And even if the money is no longer in the parents' hands, the trustee gets a judgment against the parents. What is a trustee? A trustee is an individual in bankruptcy who is an attorney that is appointed by the court to represent the interests of the unsecured creditors. They are said to step in the shoes of the debtor. So the debtor owns a bunch of property, but when they file bankruptcy, that property becomes property of the bankruptcy estate. And the trustee then effectively owns it until they say, I don't want this shit anymore. And they give it back to you. That's what a trustee is. They're there to make sure that if there are assets available for distribution to creditors, that they find them and make the distribution. The U.S. trustee is part of the Department of Justice that's there to make sure that bankruptcy fraud is not happening. What you're hearing is the questioning by the attorney for the U.S. trustee's office.
The LLC.
Okay. Okay. I just have three more questions. So during the paternity action in the state court, you did testify in an affidavit that you had almost $450,000 of cash in a checking account. Do you remember stating that under oath in an affidavit in the paternity?
This part, have you heard this? Have you heard this hearing yet?
I have not.
Oh,
It's
you're gonna
solid.
You're gonna love the next 3 minutes. Oh God, I can't wait it. You know how Gingras just filed he filed a request in the bankruptcy court today. I just looked at it for a limited appearance. He wants to be for limited purposes in the bankruptcy case. I think Gingras, based on what's about to happen next, is disqualified from ever representing Laura Owens ever again.
That was a misunderstanding with my attorney. So I was going to buy property with the defendant on that, and he knew that I was going to be borrowing the down payment from an investor who he had spoken to using this method called the Morty method, but Clayton admitted under his deposition that he spoke to the guy, and the guy had $450,000 in a money market account, and that's the proof of funds he submitted. It was never mine, and Clayton knew it was never mine.
Okay. So are you talking about Gail Lynn Rich? Is that the investor that you're referring to?
I don't know who that is.
Well, attached to your affidavit.
It was a man named Matt Bentley, and it was his mother-in-law. That could have been what her name was. That definitely could have been her name.
Okay, so because you attached a copy of this money market checking account statement to your affidavit claiming, and you admitted in your affidavit that you attached, and I'm quoting your affidavit now, I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account as shown below. And then there's an excerpt of that money market account. That's your affidavit.
So, David was my civil attorney. That was his error, and he will explain that if you have any questions. But that
well, I understand that, Ms. Owens, but you're the one who signed it under oath.
I didn't read it carefully enough, and as I said, Clayton deposed to the fact that he's the one who submitted the proof of funds. He got that information. He knew it was never mine.
Okay, so we'll explore that further too. Okay, then what's the
And if you have a question about it, I'm happy to answer it.
Well, my question is, when you made that statement in your affidavit, I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account. Was that a false statement?
I didn't write that. It's David signed it. I mean, David signed it. David was my attorney. David signed the pleading.
Well, you understand that when you sign an affidavit swearing under penalty of perjury that it's truthful, there's consequence to that. You are testing under oath and subject to penalty of perjury that is a truthful statement. But are you saying that's not truthful now?
The $450,000 was not my error. David will take that. That was not my. He signed that affidavit for me. I didn't.
Are you hearing this?
Yep.
Does this sound like an unwaivable conflict between counsel and client?
This sounds like counsel needs to get counsel.
Yep. Or hey, Ian, just
Gingrich should not
are
be in this
you allowed
proceeding?
to sign an affidavit? Are you allowed to sign an affidavit on behalf of somebody?
No.
Are you allowed to put a sworn statement of a third party on a document and then sign that third party's signature to that affidavit and then just say, hey, is this cool if I do that to your client?
You're gonna get screwed. So yeah.
Sign that. I mean, he knew that wasn't my amount of. He knows that. I mean,
You're denying that you signed the affidavit? I have a copy of it in front of me showing your signature.
I believe David had a copy on him of my signature, and yeah,
you authorized him to sign for you, correct?
If
David
I mean,
Gingrich.
if I was in that, if I was running that hearing, I'd be saying, Mr. Gingrich, I don't think it's appropriate for you to be here.
Yep.
And I suggest you get counsel.
Yep. This is a problem.
Right fucking now.
There is no world where I can sign an affidavit on behalf of a client.
No, I mean, it's...
Now, I can arrange an electronic notary to notarize their signature from a distance away from me. But no. And then this is also where the client is now making statements that put her in direct opposition to her counsel. One of them lied.
I mean, her counsel has to stand up and say, that's not true. Or he has to stand up and say,
I lied.
I am a fuck up. I am a liar. I am all of these things. And maybe I shouldn't be a lawyer anymore. And like, which is it gonna be, right? Like,
she should have invoked her fifth a long ass time ago.
And Gingrich should have been like, I am not counsel. I am not here.
This is a good one. If you can't sign an affidavit of client, can you interpretive dance it instead? I don't know. I would have advised that client to stop answering questions the second the trustee started saying, is this your statement under oath?
Yeah.
And I would have jumped in and answered every question I could as counsel, because not having my client say it, every single one.
Yeah, I guess that would be what it is.
Well, you're not accusing him of forging your signature, are you?
No.
Okay, so the fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
Yes, yeah. I think it's...
Okay, two more questions. Just can you tell me the nature of the Owens versus...
And that means that David Gingrich should not and cannot represent her ethically at any point in time in the future. She just testified under oath that he lied on her behalf.
Mm-hmm.
versus Maricini lawsuit, which is currently on appeal? What's the nature of that suit?
It's a domestic violence restraining order lawsuit.
Okay, that you had filed against this defendant, Maricini?
Yes.
And did you seek damages, any kind of recovery in that lawsuit?
No.
It was just a restraining order?
Yeah.
Okay, and then, it says it's on appeal. Who filed an appeal?
I appealed it.
Okay, when did you file the appeal?
I think it was like December 5th. Of 2025. I'm pretty sure.
And how did you get the money to pay for an appeal, to pay for appeal attorney and all the costs associated with an appeal?
I don't have an appellate attorney, and my fees were waived by the court because of my income.
Okay, so you haven't paid any kind of fees in connection with that appeal?
No.
And you are appealing a decision that denied you this restraining order?
It got dismissed because I was in the hospital and I'm on the day of the hearing. So, yeah.
And what's the nature of
that
the Owens
also
versus
appears not
Gillespie
to be accurate, but
Chalk it up for one of many.
lawsuit that concluded in Maricopa County?
That was a civil case that I filed.
And what was the nature of that suit? What was the claim?
Abortion coercion was the claim.
And were you seeking damages to recover any money in that case?
I was seeking damages, and at one point I asked that they be made to a charity, to women's charity.
Was judgment entered in your favor?
No, nobody ended up getting anything.
How was it resolved? Was it case dismissed or was there a trial?
It was, we filed a counterclaim and it was dismissed on both sides.
Somebody's got their phone on.
Yeah, I can't.
I think it's 602, whatever that number is, I can see. You can see. Somebody, please mute your phones. Thank you. I'm sorry, Ms. Owens. Can you just, so basically, I just wanted to know how.
I don't want to be interrupted by a phone ringing because I want to go to town.
It ended up being dismissed. I think they maybe my side and his side. He filed counterclaims, but neither of us ended up getting anything at the end of the day.
Okay. All right, that's all I have. I very much appreciate you answering my questions. And Mr. Haley, thank you for allowing me to take up so much time to ask these questions. But just to be clear, Ms. Owens, I do intend to have, I will be asking formally for documents, which will include those bank statements. And I will be asking you to come into my office here in downtown Phoenix for a deposition. In fact, just because since you're on the line and I don't have a phone number for you, I'm not going to ask you to reveal it on this call. But can you please look up my email and send me an email so you and I can talk on the phone to schedule. I want to accommodate your schedule for when you can come in. I don't want to ask you to come in when you're not available.
Yeah, absolutely.
Okay, so it's Jennifer Gimo. My email address is on the docket sheet.
Okay.
It's just jennifer.a.gimo@usdoj.gov.
What was that?
Mr. Reisinger for Clinton or Clayton Eckert. I don't have any questions, but I would, with your permission and Ms. Gimo's permission, like to attend the trial.
Absolutely.
Thank you.
All right. Oddly enough, people are still coming into the waiting room, so let me admit everybody, and then I'm going to ask again. You wish to examine this debtor?
Mr. Haley, this is Terry Dick. I do have one quick subject.
Yes, sir. Go ahead.
Ms. Owens, with respect to Quartet Farms, the Statement of Financial Affairs says that the business is horse sales, leasing, and showing. To your knowledge, does Quartet Farms have any horses currently for lease, sale, or show?
One is he's like for lease, but it's free.
Okay, and where is that animal kept? Is that
In
your parents'
Florida.
business? In Florida?
Yeah.
And where in Florida?
Wellington.
And who owns the property where the horse is?
I'm not sure who owns he's at like somebody's boarding barn. I'm not sure who owns it. I can get the information. I'm just not sure off the top of my head who owns it.
Okay. Other than that horse, do you know if Quartet Farms has any other assets?
Like small amounts of like tack and riding apparel, but that's it. And like old horses that are, retired.
So it does have other horses?
Yeah, it has horses in like their late 20s.
Okay, and where are those animals kept?
Those are my parents' property.
How many?
There are 7 there.
The creditors want the horses.
Does
The horses are
Quartet
worth
Farms
a
have
ton
a
of
bank
money.
account?
Yeah. I mean, glue is expensive to make, so you can.
Rob.
Bad joke. It's been 4 hours.
Yeah, and you're gonna get the horse people coming after you, and the horse people do not
I'm
F around.
kidding. I would never, ever, 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 ever advocate or accept the killing or euthanizing of horses. Horses deserve to be loved until they pass of natural causes.
Like being made into glue, apparently.
No. 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 But it's like she says they have no assets. And it's like, do you have any horses? Well, there's one for lease, but it's like for lease for free. It's like, well, that's an asset. That's a horse. What about other horses? Yeah, there's 7 more. Like, come on.
So there's one horse
Yes.
plus another 7 horses. Okay, so
Plus
8
7.
horses.
Next thing we know, there's going to be a bank account.
Any of your bills paid from Quartet's bank account?
No.
And does any money come to you from Quartet Farms?
No.
And when's the last time you've seen the Schedule C for Quartet Farms?
It was last filed in 2022. I believe they got extensions, so I think that would have been the last year.
Okay. When you get Mr. Haley that 23 tax return, if you could get him the last Schedule C for Quartet Farms.
Yeah, no problem.
All right, that's all I have. Thank you, Mr. Haley.
Okay, thank you.
Uh-huh. And then this came in. Motion for leave. So David Gingras. Motion for leave to enter limited scope appearance.
I mean, he should be seeking to leave, but like leave in the sense of like going away forever. Because that's the kind of leave he needs right now is, yeah, sir, you should leave.
As this court is aware, Local Rule 9010 takes an all or nothing approach to appearance of counsel, i.e. when a lawyer enters an appearance in a bankruptcy matter, the lawyer is ordinarily responsible for all aspects of the case until it's closed. Which all are closed. Yeah. Because the consequences are too significant. Arizona state courts historically applied the same standard. When a lawyer appeared, the lawyer was responsible for the whole case until the matter concluded or the court permitted withdrawal. This was default rule for many years. Recently, courts have begun to realize this all or nothing approach was too harsh because it could often deprive low-income litigants the ability to obtain counsel who may be willing to appear, but only for a limited purpose. Oh, you're kidding. You're going to cite the Arizona rules of professional conduct to the bankruptcy court, who's not subject to those rules?
But your limited purpose is to get your own ass out of trouble, dude.
They've not yet adopted local rules which address this beneficial practice. Despite this, Arizona's federal courts routinely agree lawyers may properly appear on a limited scope, even without seeking prior leave to do so. Okay. Very, very smart of you. Wait, cleaned up? Emphasis at cleaned up is not a site. What? And why are you citing an unreported decision? Okay.
I suspect cleaned up means that he did some formatting or something.
Probably. Good cause exists to allow undersigned counsel to enter limited scope appearance in this matter. First, undersigned is representing Ms. Owens entirely pro bono. Why? Well, because you don't want to be sued for fraud. Got it. Ms. Owens is currently seeking Chapter 7 discharge from this court, and she claims substantially no non-exempt assets and no meaningful income aside from support she's receiving from her parents. Unable to pay for representation of counsel. As a sole practitioner who is familiar with the history of the events which preceded this action, undersigned counsel is willing to provide some legal services to Ms. Owens on a pro bono basis, but not without any pre-established limits. For that reason, proposed to appear in this matter on the following limitations. He will appear and will handle all aspects of the case for a period of not more than 60 days from the date this court grants leave. Okay. If this matter is not resolved before the expiration of the 60-day period, the counsel may agree to continue representing Ms. Owens for additional limited periods as necessary. Cool. If the amount of work required by additional discovery requests from the trustee or any creditors becomes excessive, undersigned counsel may terminate its representation by filing a notice of termination. No. Upon such filing, counsel may deem to no longer represent.
If I am the court, I can respond to this with 2 words.
No.
No. You need more than no. It would just be fuck off.
Yeah.
You know,
And
the
this-
court
this is-
hereby orders the following. Fuck off.
Yeah. For the court's information, the undersigned counsel previously met and conferred with trustees counsel Jennifer Giamo. Regarding this issue, Ms. Giamo indicated she would not consent to undersigned counsel appearing on a limited scope basis without leave of court. Yeah. Because you tried to walk in and grease the skids. Okay. So that's going to be fascinating. It's going to be awesome. Lady Fang, the horse people say nay to your glue joke. I know it was very distasteful. So was that joke. Random unbreaded comments. Ian's right. The horse people don't horse around. Yep. I know. Mostly harmless fuzzball in before Lauren files for an order of protection against the trustee's lawyer. She is so screwed. Michigan farm boy Gingras wants his in the trap too. There has to be some level of romance to this, right? Like, it doesn't logically make sense.
I can't figure it out unless they're banging. Like, or unless Gingras really wants to be banging. But I mean, I just can't otherwise get there. Like,
There's just no logical. This is a lot. Like a lot.
mm-hmm.
Chris Cat Queen, thank you for gifting memberships. Tracy Z Collins, for realsies, what's her exposure? Jail? Yep. And her parents are also filing for bankruptcy. How could this affect them? Denial of discharge? Clawback actions, everyone gets sued.
That'd be brutal.
It's a lot. Like, the power that these trustees have, or the U.S. trustee has, is not inconsequential. So it's a very big impact. K-Rab 1791 question: would her winnings at horse shows be taxable? Yep, they would be. She made a few $100 is when she played hooky from a recent court hearing. They would be taxable. She has to disclose that. She didn't. She lied. Michigan farm boy, zero income when you're counting taxable and non-taxable is a huge red flag for the government. It is, and especially with bankruptcy cases. So I think this is going to be a really big problem. Really big problem for her.
I think whoever told her to declare bankruptcy, which I have suspicions about who that might be.
Could it possibly be the person who's trying to bail her out now?
Yeah, I think it rhymes with dumbass.
Yeah. This whoever did this did not do her a service. There are cases that I have told clients they cannot file bankruptcy because if they do, they open a world of hurt.
Yeah. And like when you're already facing perjury and whatever else, it is not the time to open up a bankruptcy. So like, all right.
Not smile. Not smart. K-Rab 1791, her parents already filed bankruptcy, were denied. Yep, denial of discharge already happened. So there's also clawback actions and they can get prosecuted. Chris Cat Queen, how the hell did she get any loans without income? I don't know. She might. This is also what gets people in trouble, is if there were loan applications that she filled out fraudulently. For example, misstating your income. That's what gets people in trouble for mortgage fraud. So we're just gonna have to see. Let me catch up on some of the super chats from earlier in the stream. K-Rab 1791, wouldn't Juliana Magalhaes be automatically deported? She's here on a work visa, which is no longer valid.
She'll get deported at the end of her sentence. They keep people.
Sentence.
And the reason why they do that is kind of like, so let's imagine you want somebody dead. They don't want it to be like, okay, so I will go to the United States, shoot somebody in the face, and get sentenced to like life in prison, and they just ship me back to Canada. And I'm like, sweet, I'm going to go, like pick however many countries I feel like and just murder somebody in every country. You know, if your policy is just to send people back rather than hold them in jail, then you create this tremendous incentive for like tourism of crime. And yeah. So they want people to suffer.
Yeah. If this is true, that the trustees asking loan applications, then I think prosecution. That's what they're looking for. Annabelle Feinstein, hubby's former supervisor, no longer serving Marine. I had to find edible crayons. They were a hit.
Is that a thing?
I guess so.
Oh, I mean, I'm going to start bringing one to every gun show and every whatever. When somebody says, "Oh, I'm a former Marine" or whatever, I'm just going to be like, "Do you want a crayon?"
UST stands for U.S. trustee. Yeah. Oh, the MG law. Hey, man. U.S. trustees requested loan applications for the past 3 years and a request for production from 2004 exam, or the 2004 exam. That is a big fucking problem. She needs to, the problem is that she cannot decline to provide those documents. She's required to. So you can decline to testify, but you have to provide documents. They get those, which that is how they use the 341 creditors meeting, that transcript we just heard, that audio that's under oath. They use that, and they use the documents you give them after the fact. And they say, here, you are now prosecuted. Enjoy the prosecution. 2004 exam is the section of the bankruptcy rules that allow you to basically depose the debtor, ask them additional questions, and you can require them to bring documents too. User, that's a long one. Why didn't Judge A reject a plea so the prosecution could rethink? She can't. So that wasn't a conditional plea. There are some cases where in federal court specifically, they will say we will conditionally plead guilty on the condition that the judge accepts the plea. You see that, you saw that in the Hunter Biden case famously, where it was like, we will plead guilty if the judge accepts this deal. And the judge said, nah, bro. And they said, fine, we're not pleading guilty. They went back and renegotiated, but this is not what that was. The judge, the prosecutor amended the charge down, so he couldn't revise it. Michigan Farm Boy, does the trustee want Gingras to come in fully so she can get him too? I don't know. I don't think the trustee's looking at Gingras. I think the trustee is like, hey, you're either a lawyer or you're not. And if Gingras, I think the trustee might file a motion to disqualify Gingras. I would. Like, you can't represent her. You're too intertwined. And she just accused you of being a liar or lying on her behalf.
So there's a company that makes a package that is crayons ready to eat.
Today, horses used to be made into glue. Thanks, Rob. Well, I mean, jokes have their origins different places. So, all right, guys. Okay, well, I've been streaming for 4 hours and 18 minutes, so it is time for me to wrap. Ian, you've got some stuff to go over, Bitboy Crypto specifically. That one's gonna be.
Oh, that's gonna be fun for sure.
Yeah, it's gonna be very fascinating. That 2.828 million. So we shall see. And then the Laura Owens, this bankruptcy case has now piqued my interest, so I'm going to start following this one. I've missed bankruptcy litigation. It's time we needed a new good one. So, Ian, you're streaming on Monday?
Yeah, I should. Sunday, I hope to be getting some footage. So the last time I went out to go flamethrowing,
yes,
there were high winds.
Not good flamethrowing.
My burn permit has a restriction as to like wind speed. And so we got out there and the wind was just howling, like just sideways snow. And so it was like, damn it. So I'm gonna try again Sunday to see if I can make it out there and hopefully do some flamethrowing.
That is the right call.
Saturday, I am. I've got Valentine's Day plans. So,
What are the plans? Are you allowed to share? Is it secret?
There's a guy who the guy who does like my hot sauce.
Mhm.
Because like I don't do the actual fermentation. I showed the guy my original like recipe, and when I say showed the guy my original recipe, he's like, "Do you have any idea for like flavor notes?" And I was like, "I made this sauce before. Here's a picture of the ingredients before they went into the fermentation crock." And he's like, "Oh, I can work with that." So he's like the yeah, so he's the fermentation guy, but I mean, this isn't just like a pure white label thing where like I just sort of said, "Hey, make me a thing," and I had some input, right? But anyway, he also does like these pop-up things, and so he's doing like a pop-up wine bar, and so I booked a reservation for that, and gonna be going to the pop-up wine bar thing and bringing Mrs. Runkle and having a nice outing. So
Okay, that sounds like a wonderful idea.
yeah, and I mean, I'm always pretty impressed by the stuff he does. It's gonna have food and so forth. So, yeah, I plus, you know, you gotta support your peeps, and he's my people. So yeah,
That's great. Have a great time. Happy Valentine's Day to everyone listening in the chat. I'm gonna sign off. MG Law coming in and explaining what a 2004 exam is. Like a deposition. Yeah.
can you get the transcripts for that or
Yes.
the recordings?
Yep.
Like, can we though?
It depends. So the reason why the creditors meetings are subject to FOIA, so you can request those. They're made publicly available because the bankruptcy courts operate with a lens looking inward.
I would like to see those.
It's going to be very, very, very curious to see what transpires because she's in for a world of hurt. It's not going to be fun for her. But, all right. Signing off for this evening. Thank you guys for being here. Very much appreciate it, guys. Enjoy the weekend. Happy Valentine's Day to all of those who are celebrating. Enjoy the ones you love. Go out and hug somebody that you love consensually. That was weird. I'm so tired. I'm so tired. So sleepy. Get out there, make something. You will feel better. I 100% promise. Whether it's taking some time to do a craft, make a puzzle, build something, sew something, stitch something, cross stitch, weave, anything you want. Go make something. You'll feel better. Enjoy the weekend. Cheers to all of you. Until next time, good night. Bye, guys.